Good morning.
Good morning.
Hi.
Hi, John. I'm Mark Barry. We met years ago. You probably don't remember
Are
me.
you working with the judicial? Or
No, I'm one of the assistant principals of Fossil Ridge High School. Yeah,
That's great.
good to see you.
The students are awesome.
Thank
No
you.
surprise there. And
Thank
the
you.
young man, Marcus, I think he's a freshman. He did a great job of showing me what I need to do.
Excellent.
And looking forward to this. And
Excellent.
it's really nice to be in this school.
Absolutely. It's nice to
Yeah.
have you here. Thank you very much.
Thank you,
Good
sir.
to see you.
Oh, I see. Mr. Barry?
Hold on one second. Sorry, guys. Is she their attorney? Oh, an attorney. I'll talk.
So we'll just wrap that mic on the podium, and I'll see you in the center of the stage, and then she'll just whatever you
We're still on. I can't tell you.
Good morning. Fossil Ridge Sabercats, thank you for having us out here today. My name's Rob McCallum. I'm the Public Information Officer for State Judicial, so the Supreme Court and all of our trial courts. Basically, I'm the media guy. So we also put on this program, Welcome to Courts in the Community. My colleague John Sarche, standing over there, he runs this program. He's done a lot of coordination with your principal and your teachers and getting you guys prepped for today's arguments. So as this is Courts in the Community, we have transformed your auditorium here today to the Supreme Court courtroom. So all the rules of decorum apply. No hats. I've heard the cell phones have been in bags and taken away, so that shouldn't be a problem at all. We're going to hear two arguments today. And after the first argument, counsel is going to stick around and answer questions, okay? Now, why I'm mentioning this is very important. That will be your only opportunity to ask questions about that case today, because the court will come back out at the end of the day and you can ask some questions of them, but they're not going to answer any questions about the proceedings today because they're going to start deliberating on this, and until they come down with an opinion, and when they do, we'll get it to the teachers to get to you. They won't be discussing this, and they don't talk about cases at all, ever. The opinions themselves stand. So after the second argument, we'll do the same thing. You can talk with the attorneys, and then the court will come back out, and then we'll get on with the day. So with that, I give you your principal, Dr. Chaplin.
All right, welcome. Yes. Absolutely. We're going to have Mr. Sarche talk to you just for a moment.
I'm sorry, just a quick announcement. If counsel would check in with the bailiffs, please. We just need to make sure everybody's here and ready to go. Thank you.
Perfect. All right, welcome. So glad you're here today. I have to take a moment and thank all the amazing people and the honored guests that we have with us today. So we want to welcome everybody here, as I said. And today we're honored to host our Colorado Supreme Court. And the justices here today with us are Justice Carlos A. Samur, Jr., Melissa Hart, Richard Gabriel. We have William Hood, Brian Boatwright, Monica Marquez, and Chief Justice Nathan Coates. So we're very honored to have them, and they'll be coming out and joining us on stage. I'd also like to welcome our distinguished guests. We have Senator John Kafalis. We also have our Assistant Superintendent of Secondary Schools, Mr. Scott Nielsen. We have the Sheriff's Lieutenant John Fayan. We have the PSD board member, Kathy Kipp. We have City Council members, Ken Summers, Darren Atterbury, Kristen Stevens, and we also have Steve Howard. So we want to thank them very much for joining us today. We also have, with us, Mr. Ray Martinez as well. So thank you so much. I'm not sure, I may have missed someone else on my list. Nope, we got everybody, okay. Thank you, District Attorney Clifford Rydell. Thank you so much. So we really want to thank you again for coming. So students at Fossil Family are Our Performing Arts Center has transformed into a courtroom, and it's not every day we get to do this here at Fossil Ridge. And so thank you for honoring us with Ridge behavior. As we listen to the oral arguments and we ask questions of the lawyers, just remember to always strive to demonstrate Ridge. Please remember that respect, integrity, determination, gratitude, and excellence are behaviors that follow us on our athletic field, our classrooms, the courtyards, and everyday interactions. And thank you so much for making me proud to be a SaberCat each day. And now I have the honor to turn the microphone over to the Chief Justice Nathan Coates.
Thank you, Principal Chaplain. I just wanted to say a few words before we get started today to let you all know how pleased we are to come up here. You guys have a beautiful school, a beautiful space, and hopefully you'll find this kind of educational and maybe fun watching what's going on. Just to give you a little background, we've been doing this kind of a program, which we call Courts in the Community, for now over 30 years. Twice a year, we'll pick a school that is receptive and wants us to come, and we'll come up once in the spring and once in the fall, and we do real arguments here. You know, this is not something that's been staged for your benefit. These are arguments that would be in our court in Denver, in the Supreme Court, but for the fact that we're doing them as part of this program. So the attorneys come. These are real issues. They will have an effect on these cases when we're done. Hopefully, you will enjoy and learn something from getting to see how the process actually works. Just very briefly, I'll let others, and you probably have already, been familiarized already with the nature of the process and what we do, but just to remind you, what's going to happen here is my colleagues and I, and we are a court of 7, you know, the Colorado Supreme Court. We're the highest court in the state, like the United States Supreme Court is the highest court for the country. They have 9 members, we have 7, but we do everything together and vote as a group. So we will all sit here on this bench behind me, and the attorneys will come and make their arguments to us. These are just sort of their final opportunity to put a fine point on their arguments, because they've done a lot of research, they've done writing, they've filed written briefs with us, you know, and we've studied those. So at this point in time, we'll get a chance to grill them on problems we have or things we're not sure about with their argument, and they'll get a chance to put a fine point on their arguments. I'm going to go back and join my colleagues, and we'll get ready and come out here in a few minutes, and I'll let some others speak. But before I do, I just wanted to thank in particular a few groups of people. Let me start off by thanking the Fort Collins Police Department, who's providing the security here for us. But I wanted to thank your teachers and our staff in particular, who've worked with y'all to get these issues down for you and give you an idea so you can really appreciate what's going to happen. Particularly, I was told that your teacher, Tara Rigby, and also your assistant principal, Mark Berry, were really instrumental in getting this project going, and so I wanted to thank them in particular. I'm going to leave the stage now and let your chief judge in this district, Judge Howard, take over and maybe give you a little more detail and tell you some things about the court up here. Thank you very much.
Thank you, Chief Justice Coates, and good morning, everybody. My name's Steve Howard, and I am the Chief Judge in the 8th Judicial District, which consists of Larimer County and Jackson County. As Chief Judge, I tell people I was chosen because, of course, I was the best judge. Well, the reality is Chief Judge has nothing to do, or hardly anything to do, with how good a judge you are. It has to do with whether you're willing to deal with the business end of the courts. And so that is my responsibility. We have very busy courts in the 8th Judicial District. Maybe less so in Jackson County than Larimer County. In Jackson County, there are 1,400 square miles and 1,300 people. In Larimer County, there are something like 350,000 people. And when our courthouse was built, there were probably roughly 100,000 fewer people than there are now, and our caseload in the last really 10 years, even 5 years, has increased a whole lot more than that. Unfortunately, there has been an increase, particularly in criminal filings. We have in our district 20 judges and magistrates. And all of these people are involved in what are called trial courts. And I probably should mention something a lot of people don't realize is that within the judicial department, there really are two divisions, the courts and probation. A lot of people don't recognize that probation is part of the judicial department. But within the courts, we have expanded over time, and we now have one of our magistrates has no courtroom at all. He either goes to a courtroom not in use and borrows it, or he conducts court in the jury assembly area. So we certainly are busy. We hope to have more, get another judicial officer to help us out. But in the meantime, we are in the business of conducting trials or hearings, which is different than what the Supreme Court does. We have all kinds of cases we hear, criminal cases, civil cases, domestic relations cases, probate cases, juvenile cases. There's just a real wide variety. And some of those hearings are conducted by the judges or magistrates. Some of them are jury trials. The difference between the appeals courts and our court, trial courts, is huge, because when you have a hearing or a trial, you've got attorneys, the parties are there, there are witnesses, evidence is presented either through the testimony of witnesses or through exhibits. When I was a lawyer back in the day, exhibits mostly consisted of pieces of paper. That's no longer the case. More and more, we're seeing not just photos, but videos. In criminal cases, as I'm sure you're all aware, the police have point-of-view cameras, dashboard cameras. There also is increasingly the use of computer, I don't know if animated isn't the right word, but computer demonstrations of evidence. And so that is really changed the landscape of trials and hearings. After, at the conclusion of any jury trial, the jury convenes and they render a verdict right away. Judges try to do that. Sometimes they have to take things under advisement. Once the decision is made in the trial court, then the appeals court, well, either party, sometimes both parties, or more than two parties decide they don't like what the outcome was, and they decide to appeal, and they have the right to appeal. And that's when it gets first to the Court of Appeals in most instances, or to the Supreme Court. The appeals courts, they are hearing argument as to why the law was not properly applied, whether the trial judge allowed evidence that he or she should not have allowed. They're not hearing witnesses. They have to base their decision on the record in front of them. And after they hear the legal arguments, they go back and they confer and they study the statutes, case law, cases that have been decided before and published, and the rules that apply to our courts, and they make a decision as to whether the original judgment was correct or not. And so that's what you'll be hearing today. One other thing that I really think I should mention, given the times we are in, everybody's aware of the recent Supreme Court nominee and all the things that went on with Congress or with the Senate relating to confirming now Justice Kavanaugh. And I want everybody here to understand that's not the process we have in Colorado. We have bipartisan judicial nominating commissions. Whenever there's a judicial opening, and we have just had one, just filled a district court judge position here. Only a few months ago, Justice Samore was appointed to the Supreme Court because of an opening there. The nominating commissions consist of equal numbers of Republicans, Democrats, unaffiliated people, equal numbers of attorneys and non-attorneys, and it really is not the kind of political process that you hear about in the news or that you may read about from other states. The nominating commissions submit 3 names to the governor, and we believe that those names generally are chosen, I would say, completely by the nominating commissions, chosen for non-political reasons. And as a result, we get really good judges who then stand for retention. You either vote them in or out. I'm not standing for retention, so I'm not worried about this election. You don't need to look for my name anywhere. But I think that probably concludes the time I have and my remarks, and we'll get on with the show.
Thank you, Chief Judge Howard. Always a pleasure to see you. So with that, the court has put on its robes, and we'll ask counsel to join us up here on stage, and the court will be out momentarily. And then, as I said, when we do the Q&A, just come on down if you got questions, and we'll go from there. Thanks very much.
All rise. The Supreme Court of the State of Colorado is now in session. Chief Justice Coates presiding.
Thank you. Please be seated. First case on our docket this morning is styled People versus Moorhead. We've set this argument for 1 hour. Each side will have a half an hour. And it looks like both counsel are ready, so counsel for the petitioner, you may proceed.
May it please the court, I'm Andrew Cooper for the people. Where a conviction is reversed and remanded for a new trial because of the reversal of a suppression ruling, the district court should have the discretion to consider both whether to entertain additional arguments from the prosecution about alternative reasons why the exclusionary rule might not apply, and the discretion to decide whether to allow additional evidence on those issues. The district court should have the discretion on both of those points because it is in the best position to assess whether the parties had a fair opportunity to develop those issues both in argument and in evidence at the previous stage. There's really three things I'd like to talk about that support that rule. The first is the case law. The second is the record in this case, which, as I'll explain, shows that there are reasons why the district court here might conclude that it should allow additional argument. And finally, third, I'd like to talk about the practical consequences of the rule that's adopted by this court. Looking first at the case law, the main cases that support the conclusion that I've proposed are the United States Supreme Court's decisions in Segura and Murray, and this court's decision in Schundemark.
Mr. Cooper, interestingly, you didn't mention Crippen, and I'd be interested in what you think about that. Crippen says, we've long made clear that the good faith exception to the exclusionary rule must be asserted by the prosecution at the suppression hearing or reliance on it will be considered waived. How do you distinguish that case?
Well, Crippen was an interlocutory appeal, and with an interlocutory appeal, the prosecution has lost. The broader rule on almost all appellate preservation issues is that the prevailing party can ask the appellate courts to affirm a lower court's ruling on any basis, even one that was not raised below. The situation is different where that party has lost. Essentially, for the prosecution in the suppression context, what that means is that the prosecution has to make an assessment about what risk they want to take and how much evidence they feel that they need to place in front of the trial court at that stage. That was an interlocutory appeal. That makes that difference.
Well, let me follow up on that then, if you're finished, Justice Gabriel. So your response to Crippen is pretty much the same as it was to Siri, and so interlocutory appeals are different for the reasons that you just stated. What about Arnis in the way that that seems to circumscribe the analysis? What's your thought there?
Well, Arnis doesn't address the remand option. It merely said that the affirmation can be made on the existing record if the existing record supports it as a matter of law. That doesn't, I don't think.
Doesn't it seem to suggest, though, that it should be based on the existing record, even if it's not directly on point?
No, I don't think it does. For a couple of reasons. One has to do with the purposes of the exclusionary rule, because the exclusionary rule interferes with the fact-finding process, and the purpose of its application is to function as a deterrent sanction for the police. If the police, in fact, have not done anything wrong and the evidence that they obtained is consistent with proper police conduct, then the exclusionary rule should not be applied. That Arnes simply doesn't address the question of whether a remand is appropriate. But there are 3 cases that do, and those are Segura, Murray, and Schundemark. Each of those is factually very similar to this. In each of them, there was an initial entry and observations that were later deemed by the appellate courts to be suppressible because that entry in the appellate court's conclusion was illegal. There was, though, a subsequently executed search warrant. The same items were again seen and seized, and additional items were seized. And in all 3 of those cases, the U.S. Supreme Court and this court said that, the evidence was admissible at trial because there was an independent source or an inevitable discovery of those items. With Segura, the U.S. Supreme Court said that the later observed and seized items were admissible. With Murray, the U.S. Supreme Court said that the initially observed and seized and later seized items were also admissible. And in Schundemark, this court likewise applied both of those conclusions. And in both Murray and Schundemark, the U.S. Supreme Court and this court remanded so that the district court could make those findings. And in Murray specifically, the U.S. Supreme Court disapproved of the Federal Circuit Court's conclusion that the Federal Circuit Court could make the decision in favor of the prosecution that those were a sufficient independent source, saying that no, that should be a factual determination by the district court. That's why a remand is appropriate on those issues.
Do we know in those cases whether those alternate theories for admissibility had been presented in the first instance?
In at least some of them, they were not fully explored. No, they were not.
Fully explored or presented at all?
I don't think they were presented. And on the record here, it's easily explainable why in some cases the prosecution would not have presented them and why they did not present them here. Maybe that's a good way to address that concern. Here's what happened here. So on the date of the offense, which was September 9th of 2010, the defendant's girlfriend came to the police station and gave statements about there being illegal gambling machines in an area that she had access to, and that in areas that she had seen before but were closed off to her and that she would not have access to, there were drugs and money that were proceeds from the illegal activity, as well as guns, which were potentially criminal if associated with the drug activity. Those were that girlfriend's statements. The police on that did several things. Let me take this chronologically and then get to the procedural point. The police did several things. First, before simply going there on her say-so that she had consent to go in, they took a different step. They sent a different officer out there to make observations to see if, in fact, there were folks dropping by for quick periods of time in a way that would indicate that drugs might be sold out of the house. That occurred. And then after they had received that confirmation, the police then went there with the girlfriend on her consent, which the appellate court later concluded was invalid because she didn't have authority to give the consent. But they went in, saw those initial things, but very promptly just secured the scene. And at 1900 that evening, Investigator Boyle was on scene. That's when the securing of the scene occurred with the other officers. And then that officer immediately left. His testimony on page 89 of the July 28th, 2011 the transcript, page 89, is I left to get a warrant, indicating that that's what he was planning on doing. And as soon as he returned at 20:45, only an hour and 45 minutes later, with the warrant, that's when they went in and seized entered and the locked areas and seized all the various items. Now, here's the real answer to the court's concern about why this wasn't raised here. April 13th of 2011, the defendant files a written motion to suppress. That written motion to suppress makes separate attacks on the two entries. It attacks the initial entry on the ground that the girlfriend did not have either actual authority or apparent authority. And it separately attacks the later entry on the ground that the warrant was invalid, saying variously that the warrant on its face didn't support probable cause. Second, that if it, to the extent it did establish probable cause, that was negated by the material omission of certain facts, specifically the fact that they had gone in earlier. And third, that the girlfriend was not a reliable source. Those were the attacks. An attack on the initial entry, an attack on the later seized items. The word fruits does not appear in that motion. The defendant in the April 13th, 2011 written motion was not putting on the table the issue that, well, another reason for suppressing the later seized items seized under the warrant was that those were the fruits of the earlier invalid entry. So the prosecution wasn't...
Wouldn't that have been obvious? I mean, it seems like you could argue, your argument goes the other way, that people were put on notice that there was an issue about the warrant. Would seem to me fairly obvious to say warrant was valid, and by the way, it's an independent source, or inevitable discovery. I mean, I'll cut to the chase with my concern. Well, let me ask you, if in a case where the prosecution wins on a direct appeal, interlocutory appeal to us, does the defendant get to try again when we remand? Does the defendant get, well, I lost that suppression one, I got some other ideas for why this should have been suppressed?
I think that's in the discretion of the trial court.
All right, so fair enough. So your rule would be consistent that the court would have discretion either way to let either the defense or the prosecutor do that. So as a policy matter, why does that make sense? And where do you draw the line? What factors would the court look at? My concern would be we're just going to get seriatim attempts to suppress or to fight suppression, and where does it end?
Well, and that really leads to the third major point that I want to address, which is the practical consequences of the rule. The rule that the defense is advocating and that the Court of Appeals adopted here creates great efficiency for the appellate courts in the suppression context. But it does so at the cost of huge, far greater inefficiency at the trial court level. Here's why. The appellate courts only see a very, very small fraction of the suppression issues that are litigated in the trial courts. Only where the defendant has been convicted at trial and where the defendant is choosing to raise the suppression issue. But in a whole host of cases in both the district courts and in the county courts, which have an even larger caseload, motions to suppress are filed in virtually every case. And some of those cases get pled out before the motions hearing stage, but a lot of them go to motions hearings. And the motions hearings are held. A lot of them get pled out at that point before the trial. And as a result, there's a very large volume of cases. The court needs to remember that the trial court judges, both in the district court and even more so in the county court, are sitting there with crowded dockets. And here's the practical consequence of the rule that was adopted by the Court of Appeals. So it's a Wednesday night, it's 4:45, the judge is in the middle of a suppression hearing, has another suppression hearing that the judge is going to entertain because these cases are set for trial. The judge will be letting the court staff go at at 5 o'clock, but we'll be having the lawyers and the police officers stay there and recording these on an audio recorder late into the night. And when the trial judge is signaling to the prosecutor, either explicitly or subtly, I'm going to rule in your favor on this, let's move on, the prosecutor's going to say, Your Honor, remember the Supreme Court's decision in the Moorhead case. I need to present all of these alternative arguments because even though you're going to rule in my favor now, the appellate courts might second guess that, decide that this evidence should be suppressed, and if I haven't preserved these arguments now, I'm out of luck.
And I'm going to interject because I don't understand how it would be more efficient to do that a second time, years later, on remand.
Because it's the very rare instance, this is the very rare instance where the case has gone all the way through the system, the suppression ruling has been reversed, and it's being sent back. It's being sent back anyway. This case isn't dismissed. It's reversed and remanded for a new trial. Even though this suppression ruling does gut much of the case, this case theoretically could go to trial again on the existing evidence because the girlfriend could testify, I've been in there, I saw this activity. He could be convicted on that. If he was convicted on that, the appellate courts would say, well, that is sufficient evidence. And in other cases, the suppressed evidence is much smaller, and the prosecution has a very likely opportunity to reconvict. The case is going to go forward anyway. The district court should get to decide whether to allow that additional evidence.
And under what standard? I mean, what factors should the district court take into account as to in exercising that discretion?
Whether the party had a fair opportunity to litigate the issue before.
And so why was there not a fair opportunity to litigate these two alternate theories of admissibility, independent source and inevitable discovery in this case on the first try?
Because for two reasons. First, in the April 13th, 2011 written motion, the argument that the later observed that warrant seized evidence should be suppressed as fruits was not raised. The testimony, although as I'll explain, the testimony does allow the conclusion that there is an independent source. At the, there were several suppression hearings. At the September 23rd, 2011 suppression hearing, I'd ask the court to look specifically at page 38 of that transcript and pages 51 through 53. Page 38 and 51 through 53 of the September 23rd transcript. On page 38, the judge, after all the evidence has been closed, says, I want to narrow the issues regarding suppression so that I get the briefing that I need to make my decision. And from pages 51 through 53, the prosecutor starts by, on page 51 to 52, describing the prosecutor's understanding of what issues were raised by the defendant's motions. Laboriously went through all of the issues that were actually raised by that motion, but did not say anything about fruits. And then on page 52 of that transcript, the defense attorney chimes in and says, I think the prosecutor has done an admirable job of describing the issues to be briefed. And then the judge returns to that and says, well, okay, great, because I want to make sure that we're covering them all. And then the judge raises one other issue, comes up with something that hadn't been raised by the defendant's motion, Georgia versus Randolph, because in some of the testimony, the defendant's son had testified and that he had said that the police shouldn't get to go down there. So the judge said, well, if that raises a Georgia versus Randolph issue, if that person had common authority over the area, which ultimately the court concluded he did not, then I want briefing on that too. So look then at the briefs that were filed after that, the legal argument briefs. First, if you look at the defendant's brief, at length addresses all of those legal issues that the parties agreed that they would address. And then with 2 sentences, completely undeveloped, but in the middle of that brief, the defendant throws in for the first time that, oh, well, also the evidence seized as a result of this, as the search warrant should be suppressed as illegal fruits. That was the first time the idea of fruits was put on the table. United States versus Alderman, U.S. Supreme Court decision says that although the prosecution bears the ultimate burden of proof that subsequently seized items are not tainted by earlier illegality, it's the defense that has the initial burden of production to show that there is some illegal tainting going on.
But why wouldn't, on the first piece, the warrantless search, or the apparent authority, why wouldn't it have just been a logical response to that to say, we did get a warrant, you know, so there's an independent source or inevitable discovery. I understand what you're saying about fruits, but I'm not sure why fruits necessarily call that question. I mean, you seem to say, well, the defendant didn't raise fruits, therefore it wouldn't have been logical to raise inevitable discovery, these other reasons, and I'm not sure why that's true. Don't those other reasons come into play as soon as the defendant says this search was warrantless?
I don't think so at all. It's not unusual for a police investigation to have a series of stages where different items are seized. That doesn't raise an inference that the later seized items were necessarily tainted by the earlier one. It simply doesn't.
No, I don't disagree with that, but the question to me is why, once somebody says this warrantless search it was improper, the government would logically say, well, there's an actual or apparent authority, but by the way, we also got a warrant. Wasn't that, I mean, and again, it goes back to what Justice Marcus was asking. That would seem to me there was a fair opportunity to raise that. I don't hear anything that precluded the prosecutor from raising that.
Well, and there was extensive testimony about the obtaining and execution of the warrant. The warrant was placed in evidence at the suppression hearing as an exhibit, so that response was made. What wasn't specifically addressed as a legal issue was the test for whether that's independent. And the test, it's a twofold test. Actually, one part of it is addressed. The twofold test is, first, was the officer's decision to obtain the warrant prompted by their observations during the initial, and second, were those observations included in the search warrant affidavit? Well, the observations weren't included in the search warrant affidavit. That's important because it means that the judge who issued that search warrant was not influenced by those. And although the prosecutor did not ask the question, did you make the decision to do this earlier? I'd point out 2 things. First of all, the evidence absolutely supports a conclusion. If the judge on remand could decide based on the existing evidence that the evidence supports it. And second, as I'll get to in just a second, the judge actually made a finding that it was prompted not by the later activity, but by the earlier. So let me walk through both of those things.
Well, you're going to run short on time. You want to save for rebuttal, and I'd like to talk to you about the premise that the practical considerations militate in favor of your position. So okay. May I take you there for a moment?
Sure.
Well, I just disagree with your assertion that we're going to create chaos in the dockets if we don't embrace your position, because the reality is that most cases plead at arraignment before you ever get to a suppression hearing. You do have some suppression hearings before cases plead, but far fewer. Typically, the prosecution wins at motions without consideration of sort of these ancillary points. And I think most trial judges worth their salt would say, I don't need to hear about independent source, inevitable discovery, because on a particular set of facts, it's obvious that you win for other reasons. So they would not allow the DA to say, well, you know, the Moorhead decision says that I need to make the record on this anyway. And my fear is that the reality is that there would be piecemeal litigation around what constitutes a fair opportunity and having hearings on remand where the defense is suddenly going to be saying that it's a two-way street and we're going to have much more of an effort to supplement the record with some new argument on both sides of the aisle. And so that, to me, seems like a recipe for gumming things up a lot more than what you say. So tell me why I'm wrong about that.
Well, although it's true that the largest group of cases are decided, are resolved before or at arraignment, there is a universe of cases that go to the suppression hearing. And the scenario where the prosecution wins is exactly the problem, because even though the prosecution senses that the prosecution is going to win, it needs to raise these alternative arguments and understand that the rule that's being sought here would be understood not just limited to independent source, but more broadly. I need to walk through every alternative scenario in suppression. There's going to be very few cases like this where there's an actual remand. There's going to be far more cases where the time would be taken up presenting the alternative arguments. And we also need to consider the fairness to the district court and the district court's ruling. The district court judge here was asking what issues to be briefed. The defense agreed that this was the universe of what they were challenging. They didn't raise the question of fruits. If I may,
Mr. Cooper, can I ask you a question? So if you have in a hypothetical, you have a search. The defense challenges the search with a motion to suppress, and the prosecution then at the hearing presents evidence that there was consent. And then they stop there, and they don't present evidence of an alternative theory for why there was not a Fourth Amendment violation. For example, probable cause and exigent circumstances. It gets appealed, it gets reversed. In that situation, would the prosecution get a chance to present evidence of an alternative theory as to why there was not a Fourth Amendment violation? I'm trying to figure out where you draw. Are you drawing a line between Fourth Amendment violation on the one hand and the exclusionary rule? Or are you saying regardless, the prosecution is always going to be entitled on remand to bring up a new theory?
I think the district court judge should have the discretion to determine the scope of it. And the guidance of the discretion should be whether there was a reasonable opportunity to develop the issues before. I think the way the issues were framed here, both in the defendant's motion and at the September 23rd suppression hearing, where the parties narrowly focused what issues were to be briefed, didn't give the prosecution that opportunity. And
so in the hypothetical, the defense filed a motion to suppress saying this search violated the Fourth Amendment. Why wouldn't the prosecution have had an opportunity in that case to present not only evidence of consent, but any other evidence that goes to why there was not a Fourth Amendment violation?
Well, in that scenario where there's no later entry, I mean, that might be different. In that scenario, the district court judge might decide, well, there wasn't any reason that you wouldn't have addressed it here. But here, there are effectively two different seizures, either of which could be suppressed. The initial observations could be suppressed, and the police wouldn't be able to testify when we first went in. We saw these things, but they would be able to present those later things. They're discrete and separate, and that makes this different. If I may, I'd ask to reserve my time.
Good morning. My name is Megan Morris, bar number 43963, and I represent Mr. Moorhead. The question here is essentially whether the state, when it fails to meet its burden at an original suppression hearing, gets a do-over. Here, police illegally searched Mr. Moorhead's home. Once they saw incriminating evidence inside, they decided to get a warrant. In 3 evidentiary hearings and a lengthy written briefing regarding suppression, the state never argued that the decision to get a warrant was in any way attenuated from what the police had originally seen inside the house. The state raised those arguments for the first time on appeal.
Could I interrupt right there?
Sure.
You said do-over, you said raises for the first time.
we're talking about a new trial here now as a result of you having won on appeal. Is that right?
Well, I think that what the state envisions is that, and the state can correct me if I'm wrong here, but I think what the state would envision is the potentially a remand hearing involving being able to decide whether this evidence would have nonetheless been admissible such that there would be no new trial, but I could be wrong about that. But either way, I think the problem is that, and this goes to the Kansas case, State v. Perry, that I cited, where there's a subsequent prosecution, and there it's dismissed and then refiled.
But this, do you understand the Court of Appeals to have only issued a limited remand, or did it reverse the conviction?
It did reverse the conviction. I guess I just understand the state's argument to be that they could.
Well, maybe I can ask it in a broad sort of way. So far the arguments have centered on what exactly they raised, whether they should have raised more. Let me ask you broadly, can you think of any other situation in which after one party wins on appeal and it is sent, there was error at trial, that conviction is reversed, it goes back for a new trial? What doctrine bars, or should I say limits, the other party to exactly what it raised in the first trial? Why aren't we starting over?
So I think that's based on the law of the case doctrine, which is here where the Court of Appeals has held that evidence should be suppressed. The trial court is not then free to second guess that conclusion.
And you think the law of the case doctrine applies even on a new trial?
I do, and again, that's the State v. Perry case.
And then, may I ask you, when the law of the case doctrine is applied to the same court, or a court of the same level, does it not always have discretion whether it wants to change its earlier ruling or make that ruling again from scratch?
I think at the court at the same level, but once it's gone to the appellate court and the appellate court has issued a ruling, it's not free to second guess that ruling. So at that point, the law of the case steps in.
It's not free to second guess that ruling, but does the higher court ruling limit what evidence or what could be raised if it wants to reconsider the motion for suppression?
I do think so. Where the appellate court has said this evidence ought to be suppressed, at that point, I don't think the trial court can then go back and hear further evidence or arguments regarding why it should be suppressed.
Can I ask you then, would that be true of any motion in limine, for instance? If the court made a ruling with regard to relevance and the Court of Appeals decided that it erred, given the way the trial played out, what the ruling was, could it not reconsider that motion from scratch?
So I think motions to suppress are a somewhat unique circumstance and somewhat different from motions in limine in that different evidence may become relevant in trials in different ways. And so depending on how the evidence plays out at trial, different rulings may be appropriate. But with a motion to suppress, we have a discrete hearing, or in this case, 3 hearings and then written briefing, where we have a sort of one opportunity to consider these issues and get a final ruling on these issues. And I would point out here, just to correct in terms of when the fruits issue was raised, it was in fact raised in the original motion to suppress at page 87 of the court file. The defense argued that the warrantless search was conducted without legal authority in contravention of the defendant's constitutional rights, and all fruits of the unlawful search must therefore be suppressed.
You're getting a little away from me here. I wasn't really arguing about, I was not really interested in whether you raised the issue in a way for that reason. I'm concerned with the broader proposition about the trial court's discretion with regard to a return for a new trial. Let me pursue it just a minute more, and I'll let you get on with your serious argument here. So in a motion in limine, if a party raised an issue saying certain evidence should be excluded, and the court ruled in its favor, let's say, with regard to evidence, with regard to relevance, and that was reversed on appeal, and it goes back for an entire new trial, would the moving party be prohibited from arguing that that evidence should be excluded for some other evidentiary reason? Privilege, because it didn't raise that at the motion at which it had already won by on a different ground?
I think it depends. If there was a reason to raise that at the time, potentially. But I do think, like, if the appellate court And sorry, in your scenario, you're saying if the appellate court ruled that evidence was in fact relevant and should have been admitted?
No, if
or
it reversed the ruling and sent it back down for a new trial.
Because there was irrelevant evidence
Would the
admitted.
party be able to raise other grounds for why that evidence was inadmissible?
Well, I guess in that scenario, then the evidence wouldn't, so you're saying, because in that scenario, my understanding is that the Court of Appeals would have said this evidence wouldn't be admitted on remand, correct?
It wouldn't be admitted for the reason that the trial court ruled.
Right. And so I think at that point, the party wouldn't have a reason to raise additional arguments why it wouldn't be admitted if the Court of Appeals had already said it wasn't going to be admitted on remand, but maybe I'm misunderstanding the question.
Well, I think we are misconnecting slightly. That's all right. Why don't you proceed?
But I do think, just to sort of go back to the broader point, that motions to suppress are a sort of unique creature in criminal litigation, because we have this single opportunity at which we're trying to determine whether certain searches, or here, a particular search and seizure was lawful, and whether the resulting evidence was admissible. And so at that hearing and in those proceedings, the parties always have the incentive and must raise this district attorney must raise any arguments that show why that evidence was admissible, whether that's an argument.
May I interject really quick just to pick up on Chief Justice Coates' question, and coming at a slightly different perspective. Is there a difference in your mind, based on what you're talking about now, that in a suppression ruling about the application of the exclusionary rule as a basis for non-admission versus non-admissibility for evidentiary reasons in a motion for in limine context? Is there something that's special about the exclusionary rule that makes these two things different?
So I think that the exclusionary rule, but really any motion to suppress, because it's a constitutional motion, where that's raised, I think that at that point, and maybe I can just go directly to the rule that I'd be asking this court to adopt, because I think that answers this question, which is that where the prosecution has a full and fair opportunity to litigate a suppression issue in the trial court, an appellate court should not remand for them to supply additional arguments or evidence against suppression. And they have that full and fair opportunity if they had the opportunity to present evidence and argument in support of a then existing doctrine for admitting the evidence. So whether it's an exception to the exclusionary rule or whether it's some reason why the search itself was legal, I think regardless, those need to be raised at the initial suppression hearing.
Can I interject there? You said prosecution. Should your rule say where a party has full and fair opportunity?
Yes, and I do agree that I think the rule would be the same on interlocutory appeals and on direct appeals, such that where the defense, if the defense fails to raise something that it should have raised and goes up on an interlocutory appeal, this court were to rule in favor of the prosecution, I don't think that the defense generally has the opportunity to raise new arguments at that point.
Can I ask a factual question? How specific was the motion to suppress? Because as an old trial court judge, we used to get these motions of we want to suppress all evidence because it was illegally obtained.
Sure. So the initial motion to suppress argued that the warrantless search was illegal due to the lack of authority for Ms. Sakita to consent, and then specifically said, asked for the fruits to be suppressed. There were these 3 evidentiary hearings, and then there was lengthy written briefing afterwards. In that written briefing on page 205 of the court file, the defense specifically said, based upon observations made subsequent to their initial illegal entry, law enforcement officers decided then and only then that they would apply for a search warrant. The application for the search warrant was a direct consequence of the illegal search, and thus items recovered to the warrant should be suppressed as fruits of that illegality. So I think that's
was that in the original motion, or was that part of the argument?
That's not in the original motion. That's in the argument after the 3 suppression hearings occurred.
Okay, so that's my point, is if they raise that in argument after the evidence is closed, is that a full and fair opportunity for the prosecution to have presented that evidence? I'm really, this is kind of a notice sort of a question.
And I think that it is here, where we have, again, the defense did specifically raise a fruits issue in the initial motion. At the motions hearing, the defense elicited testimony, or I can't remember whether it was the defense or the prosecution, but Mr. Moorhead's sister testified that police officers told her that they saw some things inside which caused them to seek a warrant. And then the district attorney's brief, which is a rather thorough brief, in its title recognizes that there are fruits issues here. And so I think if the district attorney disagreed with that notion that the warrant was not an independent source of evidence, it could have made that argument here, or at that point requested the opportunity to present additional evidence if it felt that that was necessary. I think it's clear here from the record that, in fact, the district attorney made a conscious decision not to raise that issue.
Okay, the final question, then I'll leave
Sure.
you alone. In your rule, you talk about a full and fair opportunity. Who's in the better position to make that decision, the appellate court or the trial court?
I think that's something that the appellate court can decide. Because what we're looking at here, I think...
No, I know they can.
Sure.
The question is, who's in the better position to make that determination?
Well, I think it's something that the appellate court should do as part of determining whether or not it's going to determine these issues on appeal. And I don't think the trial court is necessarily in a better position when we're able to see on the face of the record what the parties were able to present. So I think that's something that the appellate court would do and should do in this circumstance.
Okay, thank you.
Can I ask another factual question relating to that? In terms of the briefing, was it simultaneous briefing, or was the DA responding?
No, I believe it was responsive briefing. Mr. Moorhead's brief was filed on October 14th of 2011, and the DA's brief was filed on November 4th. So it was responsive to the defendant's brief. And again, they filed a 19-page brief. This was a rather thoroughly litigated suppression issue, and they never made that argument. Just to go back to why I think this is a conscious decision, to quote this court's decision in Quintero, where it was talking about the fact that inevitable discovery had not been raised, this court said, "This failure is no doubt attributable to the total lack of concrete evidence in the record to support the application of the rule to the facts of this case." We learned at trials and from discovery that the district attorney would have had that an officer's report said, "We observed the gambling machines which led to a search warrant at this residence." So that seems like a pretty clear indication that the officers chose to get a search warrant because of what they saw during their illegal entry. So I don't think this is, as the state is arguing here, an undeveloped issue. This is something that was developed and that the district attorney made a conscious choice not to present.
May I jump in now?
Yes.
I just wanted to ask you about whether you're essentially asking us to affirm on different grounds. It seems like you're veering away from the rationale that the Court of Appeals used, and that sort of raises the question of whether you're implicitly acknowledging Mr. Cooper's position or implicitly embracing Mr. Cooper's position about how cases like Crippen and Siri are distinguishable because they were interlocutory appeals. Can you talk about that?
No, I disagree with that. I think that the Court of Appeals did what was correct here. I think there's some tension in the Court of Appeals opinion because it says we're not going to address these issues, but then in fact goes on to address them. But I think this court can resolve that tension and hold that the waiver or the forfeiture is not the waiver of the ability to raise that argument on appeal if it appears on the face of the record as a matter of law, but rather, as the Court of Appeals recognized, they can do that, but what they're waiving or forfeiting is the right to go back and develop the record further in the trial court. So if the record...
As to issues that they had a full and fair opportunity to litigate.
Exactly,
Right.
exactly. So if they... Go ahead, sorry.
So this is more in keeping with the Arness
Yes,
case.
I think this is consistent with Arness, that as the Court of Appeals recognized when it quoted Arness, where an alternate ground for affirming a suppression ruling is apparent as a matter of law based on the undisputed facts in the record, the court can affirm on that ground, and I agree with that. And that's what the Court of Appeals, in fact, recognized here. It then specifically addressed the consent and independent or inevitable discovery arguments on their merits and concluded that they lacked support in the record that we have. So I think it did the proper thing there, and it's just a matter of some tension in the language that this court can clarify, that the forfeiture is it's forfeiting the ability to go back and further develop the record in the trial court.
Ms. Morris, good morning. So can you articulate the rule that you're asking us to adopt? Because I keep hearing the word opportunity, and just now you quoted from Arness. So what's the rule that you think we should adopt?
So in terms of where there's a full and fair opportunity, I think it's maybe easier to sort of state in the negative. I think the places where there are not a full and fair opportunity is where there's potentially a new exception established to the exclusionary rule or a new doctrine that might apply that's established after the suppression hearing, such that the prosecution wouldn't have had notice that they needed to raise that at the suppression hearing.
What about newly discovered evidence? Would that be another example?
Yes, and that this court recognized that in Moody. Again, I think that has to be limited to evidence that they could not have access to at the time of the suppression hearing, because what this court said in Roybal is that where the prosecution elects not to, they say, this court wrote, unless suppression hearings are to be conducted by installment, the prosecution must be prepared to abide the consequences of an adverse ruling when it elects not to offer probative evidence. So it's only if they've discovered evidence that they could not have had at that time. And then the last situation where I think a remand is warranted is where the prosecution presents its evidence and arguments to the trial court, but the trial court simply fails to make the necessary factual findings on them. The state does not lack a full and fair opportunity to litigate this issue simply because it gets a ruling in its favor, which is what the state seems to be arguing here. The state argues that this would be a fairly heavy burden both on district attorneys and trial courts, but I think it's important to recognize that district attorneys argue in the alternative all the time. In Briggs, I believe, this court recognized the district attorney specifically raised the independent source and attenuation rules there. This is something where I think here it would require only brief testimony if that testimony were available. The officer who's already there could say, well, we were going to seek a warrant anyway because of X, Y, and Z. And then the district attorney could argue that. I don't think that that significantly increases their burden either on the district attorney or on trial courts. Meanwhile, if we're trying to litigate these issues years down the line, that does significantly increase the burden. And I think it leads to potentially less accurate rulings when we're relying on people's faded memories rather than getting all that testimony and argument out nearer to the time of the search.
I'm gonna maybe replow ground. You seem to be implying that where there's not been a full and fair opportunity, that it's a discretionary call, yes?
A discretionary call on part of...
I mean, whether there's been a full and fair opportunity is a subjective determination. It depends. I mean, bottom line is it depends on the circumstances, right?
Well, I think there are specific kind of circumstances in which that would not be the case, but I think those can be apparent from the face of the record. So if a new exception was established, that would be something that this court would be aware of and be able to apply. This court would also know if the district attorney had presented arguments to the trial court and the trial court had not considered those.
I don't disagree with your assessment. There are times when the appellate court can do it. What I'm still going back to is when there is a discretionary call based on the circumstances that are occurring, why is not the better place to do that in the trial court? Why cannot the trial court make this exact same determination? And part of my hesitation from that comes is that there are so many dynamics that sometimes aren't conveyed on the record. You know, like Mr. Cooper talked about the press of the docket and what's pending, and you know, your rule seems fine. It's just, it seems like it's a question of where is the best place to make that determination. When you have a subjective term, shouldn't the place be where it occurred?
I guess I disagree with Mr. Cooper that things like that create a lack of a full and fair opportunity. I think I would limit the lack of full and fair opportunity to these more discrete circumstances that are apparent on the face of the record. I would just note in sort of the flip circumstance, the fact that there's a busy docket or that things went quickly is generally not an excuse for the defense failure to preserve an issue. And so I don't think that that should apply to the prosecution either. So I think that instead, this is a determination that the appellate court can in fact make and should make because it's already deciding the scope of the remand. And that by making this a discretionary call on the part of the trial courts, we would be in fact just continuing to increase the burden on the trial courts in terms of litigation.
All right, thank you.
So Ms. Morris, I infer from your use of the phrase full and fair opportunity to include a need or a reason, right?
I'm sorry, a
need or a reason to litigate something.
Sure.
And so,
That the district attorney would have to have.
exactly.
Yes.
Is that what you're saying? That wouldn't be included within it?
I think so, but I think that at a suppression hearing, the district attorney always has a reason to present evidence as to the admissibility of evidence, whether that pertains to the legality of the conduct or whether it pertains to an exception to the exclusionary rule that might apply.
So your position is that the prosecution would have the need to present evidence as to one of the exceptions to the remedy of the exclusionary rule before there has been a finding of a Fourth Amendment violation. Is that
Absolutely,
right? Okay.
absolutely. And I think the reason for that is, again, going back to the structure of suppression hearings, which is that the way these are litigated is that we have evidentiary hearings where the parties present all their evidence and argument. The prosecution doesn't know at that time whether or not it's going to get a ruling in its favor. And so there's no reason for the rule to be different based on something that it doesn't know at the time.
Can I jump in and ask you a little bit about the exclusionary rule? The Court of Appeals here seem to assume that the exclusionary rule automatically applies. And I don't think that's necessarily the case. Shouldn't we be talking about whether the exclusionary rule should even apply at all?
I disagree with that. I think the Court of Appeals, in terms of it considered the fact that it could affirm on other grounds, and so I don't think that it automatically applied the exclusionary rule. But to the extent that Your Honor is asking about the whether the court should consider in every case this sort of balance of deterrence versus the cost of applying the exclusionary rule, I disagree that that's a case-by-case determination. I think that's an appellate court function, as the court was doing in Herring and Hudson, when it's deciding whether or not to carve out new exceptions to suppression or new categorical exceptions to the exclusionary rule. I don't think that that's a trial court or an appellate court function in a particular case. Instead, in a specific case where the court is looking at whether to suppress evidence, it looks at those three established doctrines, so attenuation, inevitable discovery, and independent source. And if none of those apply, the evidence should, in fact, be suppressed. To the extent that courts consider deterrence, I think that's just part of the attenuation analysis. So when they consider the purpose and flagrancy of the police misconduct as part of attenuation analysis, that's certainly part of it. But I don't think that there's this general balancing between the cost of suppression and deterrence in an individual case. To the extent that there is, though, the conduct here is exactly the type of conduct to which the exclusionary rule was meant to apply. It's absolutely deterrable conduct. The police entered Mr. Moorhead's home based on his ex-girlfriend's consent when she did not have authority to let them into his home. They were at best very legally ambiguous circumstances, and police could have easily gotten more information as to whether or not they could legally rely on her consent. So not suppressing here, I think, would encourage police to recklessly rely on unauthorized persons' consent to search other people's property. So I do think that if this court thinks that that is a case-by-case determination, it absolutely weighs in favor of suppression here.
Could I take you back a minute while you're taking a breath to a point, and I wasn't sure I understood your answer to a question that Justice Marcus asked, which I thought was your understanding with regard to a reversal and case being sent back down for a new trial, whether a suppression matter is somehow different from the way other evidence or other rulings should be treated. And I thought I understood you to be saying, yes, it is, and a suppression motion should be locked in place even though the case is reversed and evidence is held to be inadmissible that was otherwise held admissible. Would you flesh that out a little bit?
Sure. I mean, I think that it's more, when you were talking about, determining relevance and that sort of thing, that is more of a trial-by-trial determination, whether evidence is relevant. And so that might be something where the law of the case wouldn't necessarily require the same holding or ruling on remand. But suppression issues, because of the way they are litigated, I think that is a unique circumstance in our criminal law. And I do think that this is a case where the law of the case requires that unless there's newly discovered evidence, which the prosecution can present evidence of, that otherwise the law of the case does require that suppression ruling to remain in place on retrial.
And I appreciate that you think that that was how I understood what you said. And could you tell me why? And is there any authority you can think of that would make that kind of distinction?
I think it's more of just sort of a functional argument from the way that suppression rulings are litigated, which is that we have this discrete hearing, we're determining whether evidence is admissible, and also sort of the policy consequences of the alternate rule, where if we, as a matter of course, allow remands for further litigation, then I don't think there's really a limiting principle on that besides how many exceptions to the exclusionary rule or alternate doctrines for admissibility there are. So I think the problematic thing there is that we're encouraging this sort of serial relitigation of suppression issues.
But why would that be different under the normal evidence standard? I guess my question is going to, why would the law of the case doctrine be different? Party argues, court allows in certain evidence saying it's relevant, that gets reversed on appeal, we have a new trial. Why wouldn't law of the case be exactly the same? The Court of Appeals has already ruled saying this was not relevant. You can't put it in. It would seem to be exactly the same.
No, I think that it generally is. I'm just leaving room for the possibility that certain evidence might become relevant. For instance, if somebody opens the door, it might become relevant due to different circumstances in a later trial.
Sure, but
under the same circumstances, I agree, the law of the case would apply.
Sure, but that wouldn't necessarily be inconsistent with the rule you proposed. If somebody opens the door on remand for it, then I suppose you could make an argument about there was no opportunity to litigate that. It's now a whole different scenario.
Sure. I think, yeah, I'm sorry, go ahead.
No, I was just going to say, given that, what seems to me a little different version of the difference between what happens at trial and what happens in the motion, let me ask you, are you suggesting then that if a case is reversed on the basis that some evidence was held to be inadmissible on appeal, that when it goes back down and is retried, the parties could not rely on a different theory of their case? Present different evidence?
No, I'm not suggesting that. Do you mean like present evidence other than the evidence that was held to be inadmissible?
Yes.
No, absolutely. I think the parties
Or
can
present evidence that's different from what they presented the first time.
Sure,
and maybe
absolutely.
present an entirely different theory.
No, certainly the parties can do that. All I'm saying is that where they do something, because different trials are different in terms of the fact that parties present evidence, I'm just leaving room for the fact that rulings on admissibility may differ between trials depending on the particular evidence that the parties present.
But I understand Chief Justice Coates to be talking about at the motions hearing. You're talking about a trial.
Oh, I'm sorry, I misunderstood. So you're saying...
Well, I'm not making a distinction. I'd like to hear, that's the part I'm looking at. It's why the suppression hearing should be treated differently. Or are you not really saying that it should be? Are you really saying, yeah, even at a trial, if somebody makes a procedural default at a trial, which then is he succeeds in having reversed, are you suggesting, or that the other party makes a procedural default and the other party then gets it reversed? Are you suggesting that procedural defaults in the sense of failing to make a contemporaneous objection or a waiver of some right at that stage would also apply to a subsequent trial?
No, certainly not. And I think that, so I'm sorry, it took me a while to kind of grasp where you're going, but I think the distinction between that is that where we have a trial that's reversed, then we're going through the whole trial again and potentially having different rulings or different choices being made. But where we have a suppression ruling that's being reversed, we're not going back through that suppression hearing. Instead, the ruling is just that evidence has been suppressed and you're not relitigating the issue. And so I think that's the distinction. So it does go back to sort of the structure of suppression.
But the Court of Appeals sent this back to be relitigated, right? It didn't limit it. It wasn't a limited remand to reconsider the suppression ruling, was it?
It sent it back for a new trial, but not for relitigating the suppression hearing. And so I think that's the distinction, is that where you're going through a trial and having the evidence come back through, you're redoing the whole trial versus we're not redoing the whole suppression hearing. And so I think that's the distinction. I see that I'm almost out of time, so I would just ask this court to affirm the judgment of the Court of Appeals because the state had a full and fair opportunity to litigate the issue here.
Thank you. Mr. Cooper, you have a little bit of time left.
Three points. First, question of whether the police decided to seek a warrant only after seeing the gambling devices or before is a fact question that must be made by the district court judge. It cannot be made by the Court of Appeals. The district court judge in this case actually includes a sentence that suggests the district court has already concluded on the existing evidence that the decision was made beforehand. Let me quote that statement. Quote, as a result of the information provided by Ms. Hikita, Investigator Boyle left the residence to complete an affidavit, not based on the gambling devices observation, but on the information earlier provided. That's a fact question for the judge to be decided on remand. Second, the rule that the defense is asking for would work a great change in practice. Look at this court's decision in Spring, the Spring case in 1985. Although footnote 6 says, well, there's a new issue, Oregon versus Elstad, that allows and is in the district court's discretion whether to address that. The main body of the text, page 876, remands on attenuation quite apart from that separate issue.
Mr. Cooper, your time's just about up or is up, but may I ask, do you disagree with her test about where a party's had a full and fair opportunity to litigate the discretion? Do you disagree with sort of the concept of that rule?
I think it's a question of, I don't, but I think it's a question of which court
That was going to be my next question, is whether your position is, I don't disagree with what rule she's proposing. The issue is whether it's the appellate court or the trial court that makes that determination.
It should be the district court, and I think if you were to remand and ask this district court, the district court judge in this case would say, I had no idea the issue of fruits was in play. We narrowed the issue. That was not a subject of my ruling.
All right, thank you.
Because it was not in play.
Okay, Mr. Cooper, now your time really has run out. I'd like to thank both counsel for their arguments. I appreciate it, very helpful. This case will stand submitted, and we'll be in recess for however long it takes you all to talk to the attorneys or whatever you do in between, and then we'll be back up for the second argument.
You may be seated. Well, we're going to take the opportunity now. Mr. Cooper and Ms. Morris have agreed to stick around for a few minutes and answer some questions. As I mentioned before, this will be your only opportunity to ask questions about the case today. And I think if you were paying attention, you saw that the court had a lot of questions today too, right? So that's why we call our court a hot court, is because counsel can come out sometimes and all of a sudden their argument's gone because the court starts asking questions and they get off track or they have to get back. So with that, who's got some questions? We've got some microphones down front here. Please keep the chatter to a minimum if you would, because I think those who have questions deserve to be heard, and the answers deserve to be heard as well. No questions out there? Oh, here we go. Come on down. No, come on, no. Nobody's got any questions about, oh, here we are. That'll start. You guys want to come in the center here and we can share this microphone? And if a question's specific to either side, please let them know.
Is this just about the case or just anything?
You can ask them anything that you would like, where they went to, how they got to their office, what offices they work in, where they went to school, what they studied, anything you would like.
Okay. I was interested in the nomination process for the justices, and my question was, how do we reduce the impact of politics in our judicial branch?
Let's save that question for when the court comes back out, because they're in a better position to address that.
Sounds good.
Okay. Over here.
Yes, so this was for both of you. So how do you prepare differently for, say, a trial case versus an appeals case?
Well, A trial is much more fact-intensive. That involves preparation of witnesses and a thought process mostly about how the jury is going to understand the evidence and think about it. There is some legal research because there are legal issues that are addressed by the trial judge, but in this setting, it's much more legal issues and less about factual development. The facts are what they are in the appellate record. The other difference is in the trial court, the parties are mostly concerned with the outcome of that particular case. In this setting, at least, I'm concerned about how the rule would apply to a broad set of cases because the rule that they make here will affect other cases down the road. So, I mean, there are rare instances in which I care much more about the rule as it would affect those other cases than about the outcome of the particular case.
Yes, I mostly agree with what Mr. Cooper was saying. I was a trial public defender before I became an appellate public defender, and it's much more focused on preparing your witnesses and jury instructions and being prepared for that particular case, whereas this is much more about having, both have binders full of cases and notes on the law that are, and have to deal with the policy consequences of our decisions.
Over here.
So my question is for both of you as well. After the appellate court made its ruling, the prosecution released a brief that it felt that the decision of the appellate court was mostly based off of procedure, and I'm curious how both of you feel about that argument.
So is your question because they briefed the idea of waiver and not the idea of the substance of the arguments?
Yes.
Yes. I assume you've read our briefs.
Yes.
And yes, so that was certainly part of my argument, was that I think the Court of Appeals had addressed the merits of the issue, and so certainly that's my position.
Well, and I'm not completely sure if I understand your question, but let me try to answer it anyway. And you can let me know if this answers it. This court, the Colorado Supreme Court, gets to decide whether to hear a case or not through a process called a petition for writ of certiorari. We filed one of those petitions and actually asked this court to look at 3 different issues. This court only agreed to hear one issue, which is the one that you heard today.
It should be noted, too, that the Supreme Court only takes about 8% of what it's asked to hear. So that's a very, very thin margin to get into here.
I had a question about how you receive your cases. How you receive your cases as attorneys. Do you choose your cases or are they assigned to you?
I guess on the prosecution side, it's different at the trial level and at the appellate level. At the trial level, the prosecution decides whether to prosecute the case. The police investigate an incident. They file a proposed court filing with the district attorney, but the district attorney assesses it and decides whether it's appropriate for it to be charged. So in a sense, there's a decision there about whether the case should go forward. In criminal appeals, if the defendant is convicted and appeals the conviction, those simply come to us. But once they're resolved by the Court of Appeals, then we do make a decision about whether to ask this court to look at the case.
And on the public defense side, our office represents anyone who cannot afford an attorney on appeal. And within our office, our cases are just assigned to us. It's not something that we pick. So this case was assigned to me several years ago for when I first, was doing appeals, and then it's taken some time to wind its way up here.
So sort of similar to the previous question, have you guys ever been assigned arguments, or have you guys ever had to argue for something that you don't personally believe? And if so, how do you go about that?
So, I mean, it's interesting. As a public defender, you're representing a particular client, and so your duty is to make the arguments are the best for them in their particular case. So I don't have any recollection of making arguments that I thought were particularly wrong, but it's something where ultimately your duty is to make the best argument for that person in that case.
And on my side, generally, the answer to that question is no. Very much at the trial level, if a prosecutor doesn't think that the person is guilty, the prosecutor doesn't go forward. So in that sense, the prosecutor believes in what they're pursuing. At the appellate level, likewise, the same is true. If we don't think that a legal argument ought to be the rule, then we wouldn't pursue it. As an example, there's a fairly recent U.S. Supreme Court decision that talks about whether the police, upon arresting someone, should be able to troll through the person's cell phone and look at all their messages. Even before that became the rule that the police can't do that, my guidance to the police was, no, that's prohibited by the Fourth Amendment. So there's a decision at that level, too, about whether it's appropriate.
Thank you.
My question is that were you a part of a team of lawyers working together on this case? And if so, why were you the spokespersons for this case?
I'm actually here because the person who handled this case earlier is on vacation in Spain. So that's the reason I'm here.
So our cases are handled individually, so no, this is just my case. I do, with all of my arguments, other lawyers in our office will moot us, meaning they'll do like a pretend argument where they'll pretend to be the justices beforehand and read our briefs and ask us questions to prepare us for it. So other lawyers in your office definitely help you out, help brainstorm things, but the case itself is just my case.
Hi, this question is addressed to both of you. Where did both of you receive your education, and is there any advice you'd give to anyone here looking to receive higher education in law? Thank you.
Sure. So I am from North Carolina originally. I went to the University of North Carolina for undergrad and got my degree in public policy and economics there. I was originally going in to be a biology major, and somehow that got lost along the way. So I'm the only non-science person in my family, and I want to make a pitch for humanities. They're lovely. I think they're important, and despite the focus on STEM, you should totally enjoy your English and history classes, and that's really important for law school, if you want to go to law school, to be able to write well and to think through your arguments and have critical thinking skills. After I finished undergrad, I went straight to law school at New York University, and then came out here.
Well, after college, after high school, I went to college at a place called the University of Chicago and studied history. I was thinking about becoming a lawyer then, but didn't right away. Went into the Navy for a while, did that, then went to law school at the University of Michigan, and I've been doing stuff like this ever since.
Thank you.
So for pertaining to the questions that the justices ask you, do you have information about the questions beforehand, or are you answering them as they come? And if that is so, how do you prepare for that?
You have to think through, you don't know what questions they're going to ask. You try to anticipate it by simply putting yourself in their position and thinking, well, what are they likely to ask, talking to others and asking them, what questions do you think might come up? That's basically the process.
Awesome, thank you.
Okay. I guess just for clarification's sake, do suppression hearings take place in a separate session, or do they take place in the same session as a trial?
So I think it depends, but most of the time they're beforehand. So this suppression hearing was several months before trial. So it's something that happens beforehand, and then the parties can prepare for trial knowing what evidence is going to be admitted.
Okay, thank you.
Let's have a round of applause for Ms. Morris and Mr. Cooper. Thank you very much. So with that, as I said, the court is ready to come out. We're going to give counsel just a couple of minutes here to swap, and we'll be on our way. Thank you very much, Mr. Cooper. All right. Same thing, after the argument's over, come on down. We'll ask questions while the court's back there grinding away on this case, and then they'll come back out and you can ask questions of them.
Thank you. Please be seated. The next argument on our docket this morning is styled People versus Kubugu. We've also set this argument for 1 hour, so there'll be a half hour per side. Counsel, look like you're both in place. Counsel for the petitioner, when you're ready, go ahead.
Good morning. May it please the court. My name is Rebecca Adams. My registration number is 31044, and I represent the people in this matter. As pertinent here, the Court of Appeals reversed the defendant's convictions for child abuse, reckless driving, and driving while ability impaired, holding that the officer's testimony at trial was inadmissible expert testimony. Now, I understand that the court is familiar with the underlying facts of this case, but because the facts are relevant to the issues before the court, I would like to briefly address those facts before I begin and address the merits. Now, in this case, while conducting an unrelated traffic stop, the officer heard car horns honking, and he turned and saw a red Honda pulling out of a parking lot in front of traffic. A few seconds later, the officer heard the screeching of tires and more car horns, and saw the same car make a U-turn in front of oncoming traffic, causing other cars to brake in order to avoid a collision. The Honda approached the officer from behind at a slow rate of speed, changed lanes without signaling, and failed to completely move into the other lane before passing the officer. He then turned into a nearby apartment complex and parked in a parking space that was near to the officer and made eye contact with the officer. The officer had been able to jot down the license plate number of the vehicle and called dispatch. The officer then approached the car in the parking lot, saw that there was a child in the car, and as he did so, he observed the defendant duck down into the car, put the car in reverse, and back up over a bush. The defendant then tried to drive the car out of the parking lot, but another officer had approached and entered the parking lot, effectively blocking the exit. So the defendant drove to the far end of the parking lot, parked in the last space, got out of his vehicle, and began walking briskly away from the officer. The officer approached, identified himself as a police officer, and ordered the defendant to stop. He did not stop and continued walking at a fast pace. The officer also noticed that the child was attempting to keep up with the defendant. When the defendant ultimately reached the dead end, the officers were able to order him to the ground at gunpoint. The officer detected a strong odor of alcohol coming from the defendant, and he was handcuffed and placed in the back of the police car. The officers then discovered empty beer cans in the back of the defendant's car. The defendant was advised of Colorado's express consent law and refused to take a blood or a breath test. Now, at trial, the officer testified that he could detect a strong odor of alcohol on the defendant. On cross-examination, defense counsel asked the officer whether it was possible that any alcohol had spilled on the defendant's jacket, implying that the strong odor of alcohol could have come from spilled alcohol. On redirect examination, the prosecutor asked the officer whether the alcohol coming from an intoxicated person's breath is different than alcohol that may have been spilled, and the officer said yes. The prosecutor then asked the officer to explain why that is, and at that point, the defendant objected. The trial court allowed the testimony, and the officer explained that when a person exhales alcohol, it's coming out of their system, and that the alcohol that is spilled does not have a metabolized odor. The prosecutor then asked if the officer noticed any smell coming from the defendant's jacket, and he said that the smell was coming from the defendant's person and breath, and that he could smell the odor every time he opened the door to the police car, and that odor stayed with the defendant during the entirety of their encounter.
Ms. Adams, may I ask, the officer also testified at some length about his credentials and training in this area too, correct?
Yes, prior to this testimony, he did give background information regarding his training and experience.
So what would be the basis to say that an ordinary person would know the difference between a metabolized smell of alcohol and some other smell? I mean, that's kind of where I get hung up in this case. I mean, when you start, I've been trained, you know, et cetera, here's all my training, and then starts talking about words like metabolized. I don't even know what metabolized alcohol is. So how would we say that an ordinary person would know that?
Well, and the test is really what's the basis for the opinion? And would an ordinary person be expected to know certain information or have certain experiences? And in this case, as the trial court found, this was really a simple question of mouth odor. I think people can certainly understand that alcohol that has been spilled smells differently than alcohol that has been ingested and is coming off of a person's breath. It's no different than this morning when I was driving up here, I spilled coffee on my pants. That smells incredibly different than my breath after I've had a few cups of coffee, unfortunately. So I think these are things that are within the realm of common experience of ordinary people.
What do we make about the fact that on cross-examination of CN, the defense witness, the prosecutor specifically seized on the police officer's expertise? And I don't remember the exact question, but it was along the lines of, you know, wouldn't somebody who's been through the training and this and that know better than you? I mean, it strikes me as a little bit of a chutzpah argument to say this was lay testimony when the prosecutor used that evidence, that expertise, to say, I'm more credible than your witness. I'm pushing back, of course, but I'd be interested in your response.
Sure, and I do think that the prosecutor's emphasis on the officer's training and experience arguably creates a closer question. But again, the essential question remains whether the testimony could be expected to be based on an ordinary person's experiences and knowledge. It's not unusual for witnesses to rely on their own experiences and knowledge when testifying. And that doesn't, just because the officer has had training, that doesn't necessarily turn his testimony into expert testimony if this is something that an ordinary person could understand based on their common everyday experiences.
Don't we need to be concerned, though, that the way this testimony comes in, or at least the questions that are prefacing this, are, officer, based on your specialized training and experience, don't you think X, right? I mean, it seems like all of these questions on direct were couched based on your training and experience, based on your training and experience. Doesn't that lend an expertise and a weight to that testimony, and deliberately so?
And again, I do think that creates a closer question. However, there wasn't a question about whether this was specialized training and experience. This was simply whether the officer had training and experience in dealing with intoxicated persons, which was really no different than defense witness who offered similar testimony. So while he was relying on his training and experience was not of such a specialized nature that it was different from anyone else who's had experience with intoxicated persons or people who have been drinking.
Well, let me push back a little bit there, because I've read many of these types of cases, and this is actually the first time I've encountered this wet lab training, and the idea that I can tell, this officer said he could tell the difference between a sip that was just taken 5 minutes ago versus alcohol that was consumed sometime in the past. I mean, that does strike me as specialized training.
Well, and I'm glad you asked that question, because that was something that the Court of Appeals focused on in their opinion as well. And I would like to point out that the only discussion of the wet lab took place during the initial questions of the officer regarding his training and experience, where he mentioned that he had participated in wet labs. And he explained that a wet lab is where individuals are brought before people going through a type of certification at different levels of alcohol consumption so that they can observe the difference between someone who's had, he said, say 1 beer versus 5. And there was no reliance on that particular experience when he answered these other questions. There's also no indication from the record that his experience in the wet lab involved anything regarding mouth odor. All he said was that he had the opportunity to observe people who had ingested various amounts of alcohol. But he wasn't relying on his wet lab experience particularly when he gave his subsequent opinions later on in his testimony. And again, I'm not sure that a wet lab in and of itself is technically specialized training. I mean, we all have experience watching other people who have ingested certain amounts of alcohol. We can certainly tell the difference between a person who's had one glass of wine with dinner and someone who has had many glasses of wine over a short period of time. So these are not things, again, that are outside the realm of the common experience.
But common experience in that sense usually involves someone's gait, the way they're moving, maybe bloodshot eyes. I don't know that common experience allows us to differentiate between the odor of metabolized alcohol coming from someone's breath as opposed to spilled alcohol. So help me with that. I just question the notion that most people would be able to make that that distinction based on common experience, that particular distinction.
And again, I think that it's no different than the coffee. The way that smells when it's brewing in my kitchen is different than my breath smells. It's no different than cooking garlic and how that smells on the stove versus after I've ingested garlic. It smells different. People understand that. And while he used the term metabolize, he wasn't giving a biology lesson here. He wasn't explaining how the body processes alcohol. He wasn't talking about absorption and elimination rates. He was simply using that as a way to explain that once the alcohol has entered your system, it takes on a different smell. But the fact that it smells different is something that everyone has experience with.
But then why do we go through all the credentials? I mean, isn't the purpose here to present to the jury a picture, this is an expert. This person knows more than everybody else, so you should listen. And as Justice Marcus pointed out, there was constant reference to that training and expertise and wet labs. I mean, I think that's kind of an issue when, and I know you didn't try the case, when the prosecutor tries it that way, you run a risk of saying, well, you're presenting this person as an expert. You don't get to say it wasn't on appeal. So if an ordinary person knew this, why did the jury have to hear all about the expertise and the wet lab training?
Well, and again, this court touched on this issue in Venalonzo, but just because the witness has provided evidence of their training and experience, that doesn't necessarily elevate their testimony to expert testimony.
But it did play a role, I think, in our analysis in the Ramos case, that the questions there about the blood spatter had been couched in terms of specialized training and experience.
Yes, that was a factor in that case. I think there was also a great deal of reliance on that in closing argument, which was not the case here. The prosecutor in this case did not rely on this testimony in closing argument, so that's a distinction from the Ramos case. I also think that when you're dealing with blood spatter, that's a very different issue than simply a mouth odor, which people do come in contact with in their everyday experiences throughout the course of their daily lives.
But again, I think common experience might suggest that when someone's really intoxicated, you might be able to notice the mouth odor. And police officers are more typically coming into contact, unfortunately, coming into contact with people who are severely intoxicated. So they have their training experience as police officers gives them a specialization that ordinary citizens would lack. Wouldn't you agree?
Well, I think they may have more experience. But again, this isn't anything that requires specialized knowledge or training. It's simply the fact that this officer may have come in contact with more intoxicated people, and he may have been exposed to more of that. But again, this doesn't require any technical training to understand that the odor of alcohol is strong on someone who has ingested a lot of alcohol.
But this officer this wasn't just a one-question situation, right? And this officer talked about the difference in smell between spilled alcohol and consumed alcohol.
Correct.
The difference in smell between having consumed alcohol recently versus some time ago, and the difference in smell between consuming a little bit of alcohol versus a lot of alcohol.
Correct. And obviously these questions took place over the course of this officer's testimony. He did talk about that if you've consumed a lot of alcohol, the odor is stronger. Again, I don't think that requires any specialized expertise. He talks about the difference in smell between alcohol that has been spilled and alcohol that has been ingested that's coming off of someone's breath. Again, I don't think that's anything that requires any specialized knowledge or experience. So while the officer did give his opinion, these are not things that an ordinary person could not know based on their own experiences. This doesn't require specialized training. So while the officer did have experience with multiple intoxicated persons over the course of his career, it's not anything that an ordinary person could not know.
You think an ordinary person would be able to tell just based on the smell of alcohol whether someone, number one, had consumed alcohol as opposed to had spilled it on themselves, number two, how much they've had to drink, and number three, how recently?
Well, I don't think that he said specifically on cross-examination, or I think it was recross-examination, that he could not tell the amount of alcohol consumed based on the odor of alcohol coming off of someone's breath. So the officer was very clear that he couldn't tell you that. He couldn't tell you exactly how much this person had consumed based on the amount of based on the smell of this person's breath. But what he could tell you is that the odor was very strong, which was consistent with someone who had had more than one glass of alcohol.
Didn't he say it was consistent with the number of beer cans?
He did.
Doesn't that go to the amount?
I think that goes to the fact that this was a very strong smell, that this defendant had a very strong smell of alcohol about his person.
So the officer does repeatedly, in answering questions about the alcohol, refer to his training. Is that something that we should be concerned about? He mentions earlier on that he gets about 8 hours of training in alcohol detection every year, which is certainly more than your average person. And then when he's answering the question about the more you've had to drink, the stronger the odor is, he says, in my experience and training, the more that the individual has had to drink, the stronger the odor is. And then he's asked, okay, and how strong was the odor? And says, I described it as strong. So he's taking that training that he has and saying, I've learned that the smell will be stronger on someone's breath because of the training I've had.
Correct. But again, the test is really, what is the basis for the opinion? And could an ordinary person be able to have this same information? Or do you need specialized training? And really, it's not specialized training. It's simply the fact that he has a lot of contact with people who have consumed alcohol. But any ordinary person who has experience with people who have consumed alcohol can tell you that a person's breath smells differently when they've been drinking. They can tell you whether that odor is very strong or whether it's not. I mean, these are not something outside the realm of the common experience of the ordinary person. And just because this officer has training does not elevate his testimony to expert testimony.
But didn't he elevate his testimony to expert testimony by doing it? I mean, it kind of feels like the prosecution's trying to have both sides of the aisle here in the sense of, look at me, this is how I'm an expert in this area, but now saying, oh, but this was just ordinary lay, anybody could testify to it. I mean, when the witness makes himself an expert, how do we go, nah, he's not an expert?
Well, I don't think that the witness did make himself an expert here. I think relying on your training and experience does not mean it's expert testimony. What we're looking at is whether this is specialized knowledge, whether this is scientific or technical. Really, all he's doing is offering his opinion about the odor of this person's breath, which is not something that requires any specialized knowledge.
Well, but he goes, I mean, as Justice Moore points out, I mean, he's attributing the odor to the number of beer cans. I don't know that the ordinary person is going to say, I smelled this person's breath, they've had 6 beers.
Well, and certainly that's not what happened here. He said it was consistent, but what he meant was the odor was strong. Certainly any person could offer that opinion based on smelling someone's breath. They could say whether or not that's strong. He was very clear in his response to defense counsel's question that he could not tell you exactly how much this defendant had had to drink based on the odor of alcohol that was emanating from his person. But he did say that it was a strong odor, which was consistent with the fact that there were multiple empty beer cans in the car, and inconsistent with the defendant's claim that he had simply, moments before opened a beer can and had a few sips as he was getting out of his car.
For purposes of this kind of analysis, do we need to make a distinction between experience and training?
I mean, I think what we're looking at is whether this is some type of specialized knowledge that an ordinary person would not be able to have.
And the question whether something is specialized is always kind of a debate.
Sure.
But if you have to be trained, educated, that suggests you've been to course material or you've read something. Is that different? Does that in itself push you in the direction of expertise? of
No.
something that people without that training wouldn't know?
No, I don't think so. Again, I think we have to look at each case based on the facts of that case. You know, in Venalonzo, we have a forensic interviewer who has spent a great deal of time in training and dealing with children and is able to offer her opinion, you know, regarding how children act. But this court found that that's no different than anyone else who has spent time with children. So even though in that case that witness had specialized training and a great deal of time spent with children, it's really no different than anyone else who also spends time with children. And in this case, it's the same thing. While this officer had training and experience and had obviously a great deal of experience dealing with intoxicated persons, all he was really talking about in this case was the odor of alcohol, which is something that anyone, any common person could have experience with.
Is that, in a way, is that us saying, you're wrong, witness, you didn't know this on the basis of your training? Anybody would know this just from being a human being and being an adult.
I'm sorry, I think I missed the first part.
Well, he said it was on the basis of his training, but you seem to be saying, I take it, that the opinions he gave were not based on training, that anybody would know those even if they didn't have that training.
Yeah, I think that's correct. I think that his training, I mean, there's nothing about his training that was significantly linked to detecting the odor of alcohol. Really, this is about his experience as a police officer and coming in contact with intoxicated individuals. There's nothing about his training that specifically focused on the content of his testimony.
And I guess where I'm going with that then is, and therefore are we saying to him, you're wrong, this wasn't based on your training, or it's irrelevant if you're saying this was based on your training as long as other people would know it even without that training?
No, I don't think so. Again, I think this is similar to the Venalonzo case where you can rely on your training and experience. Witnesses do that all of the time. And that doesn't necessarily elevate his testimony to expert testimony. He was relying on his experience as a police officer, and whether he was using those terms interchangeably or not, his testimony was still lay testimony because at the end of the day, what we're looking at is what is the basis for this opinion? Can someone understand this? Can someone form this opinion without specialized knowledge? And in this case, the answer is yes.
But I have to come back to the cross-examination of CN. I mean, I didn't write it in my notes here verbatim, but it was essentially, when it comes to determining someone's intoxication level, a trained officer who has been on the street for 10 years, had numerous classes on detecting alcohol, has a better understanding. How can, when the prosecution is using that expertise to cross-examine the defense expert, who is no question was a layperson, and say, this cop knows better because of all the training and experience in classes, do we say, no, it really wasn't expert, when the prosecution used it as expert testimony?
Well, the prosecution asked the witness whether or not we should rely more heavily on the officer's testimony, and the witness said no. She said based on her experiences and her life experience, she was just as able to offer this testimony. So she rejected the prosecution's argument that this was somehow, that his testimony was somehow more important than
She
hers.
did, but the point was made to the jury, right? I mean, they're hearing the prosecutor's question about that. The prosecutor's constantly emphasizing the training and expertise that the officer has. And that's, I'm troubled by that. When the prosecutor, I mean, if it was just ordinary, then the issue should have been, the normal cross would be, this officer had a better opportunity to observe than you did. Then that makes sense to me. That's one ordinary person versus another. But when you use the expertise, that seems different to me. And I guess I'm still not hearing an answer to that, with all respect.
Well, I think part of it is this. When we're asking jurors to evaluate the credibility of witnesses, we are asking them to look at whether these witnesses have the necessary experience to offer these opinions. Certainly an officer who has experience in dealing with intoxicated persons, maybe we can rely more heavily on his opinion than a lay witness who's only been in contact with a few people, because the officer has had more experience. But that experience alone doesn't make it expert testimony, and it's not experience that was based on specialized knowledge.
But that is part of the experience that makes it expert testimony, right? Because an ordinary person wouldn't usually have had experience in dealing with intoxicated people 100 times, right? Isn't that part of what makes him different than the ordinary person?
But the question is whether an ordinary person could be expected to know certain things, whether you would need specialized training to make these determinations. And in this particular case, no, you wouldn't. While this officer may have done this multiple times and been in contact with more people, this is no different than the witness in Ben Alonzo, who had had much more contact with children than the ordinary person, who may have only been around children a few times, but they can still understand the concepts.
But you've been saying throughout, this wasn't so much training, it was his experience.
Correct.
Right?
Yes.
Now you're saying experience doesn't really matter.
Your experience does matter, but it's whether or not that's based on this specialized knowledge. That's what elevates it to expert testimony.
Have we said that? Is that what we've said?
Yes, it's lay testimony if it's not based on scientific, technical, or other specialized knowledge.
So an officer who relies on his experience that an ordinary person would not be expected to have, you don't think that goes to whether it's expert testimony or not?
No, because ordinary persons do have these experiences and can understand this. They are certainly familiar with the odor of alcohol. They're certainly familiar with the way alcohol smells on a person's breath. They certainly can tell you whether someone has a stronger odor based on the number of drinks they've had. These are not things outside the realm of understanding of an ordinary person.
Can you remind me, how did the prosecution argue this in closing? Did they rely on the...
They did not rely on this testimony in closing argument.
Okay. Will you quickly turn then to harmless error?
Yes. With my remaining time, I would like to talk a little bit about harmless error in this particular case, because there was overwhelming evidence here in this particular case. We have the officer's observations of the defendant's driving. We have the defendant's evasive actions in the parking lot. We have the defendant's refusal to take a blood or a breath test under the express consent law. We have open beer cans in the car. And the car, this belonged to the defendant's ex-wife. He had borrowed it from her a few hours before, and she testified that those beer cans were not in the car when she loaned the car to the defendant. And we have the strong odor of alcohol that the officer testified to. Again, the prosecutor did not rely on this in closing argument. The jury ultimately convicted the defendant of the lesser offense of DWAI rather than DUI, demonstrating that the officer's testimony was not unduly prejudicial. We have a defense witness who gave similar testimony. And again, the testimony that was presented here was responsive to defense counsel's cross-examination. And at the end of the day, really all the officer said was he detected a strong odor of alcohol and that it was coming from the defendant's breath and person and not from his jacket. The officer agreed that he could not determine the quantity of alcohol consumed based on that odor, and he agreed with defense counsel that beer can have a stronger odor than other forms of alcohol. So when considering all of that as a whole, any error in this case was certainly harmless.
Can I ask a quick question about the presumption based on the failure to take the blood or breath test? Is that something the jury is instructed on?
And I don't know if there was an instruction given in this case, and I'm not even sure.
So how does that presumption then play into harmless error here? If the jury isn't made aware of that?
And again, I'm not sure if the jury was in this particular case.
Okay.
Obviously, if the jury isn't aware of that, but it is, I think, something that we can consider. If there are no further questions, I'll reserve the remainder of my time for rebuttal.
You may.
Good morning. May it please the court. My name is Brian Cox, registration number 50258, and I represent Mr. Kabugu. In People v. Stewart, this court established that where a police officer's testimony is based not only on their personal observations, but also on their training and expertise, then that officer needs to be duly qualified as an expert. This court clarified the test in Van Alonzo. Opposing counsel, I believe, summarized it appropriately, saying that the question is really what is the basis of the opinion. Here,
Can I stop you right there just for a minute, not to throw you off too much, but I think you're hitting into what seems like opposing counsel's primary argument, or the major thing for us, which is, what did we say in Venalonzo? Did we, in Venalonzo, as your opponent argues, did we say, notwithstanding the fact that the witness testified that it was on that her testimony was on the basis of training and experience, that nevertheless we found it was not expert testimony?
So the exact language in Venalonzo was whether the testimony could be expected to be based on an ordinary person's experience or knowledge.
Is that without regard to whether the witness says, my testimony is based on my training and experience?
Well, I think when you look at Venalonzo in concert with Ramos, which was decided at about the same time, it becomes clear that you do in fact look at both. And that certainly when there is a lot of emphasis placed on the officer's training and experience by the prosecution and by the witness, then that is a factor that this court looks at as well.
Does a lot of emphasis go to the question whether it's expertise or whether it's harmful?
Well, in Ramos, that was discussed in the context of whether there was error, not in the context of whether it warranted reversal. And so I believe when you read the two cases in concert, the rule does explicitly look at how the evidence is presented to the jury, not just in the abstract whether an ordinary person might be able to do this. But I think that either way that you look at it, we reach the same result here. I want to start with what Mr. Kabugu does not dispute. Certainly a lay witness can testify to ordinary observations like if someone has slurred speech, if someone can't walk steadily, if someone has watery eyes. There's well-established case law that those sorts of things are appropriate subjects of lay testimony. And in fact, some of the testimony here was that those indicia of intoxication did not exist. But Officer Luden's testimony went way beyond those commonly accepted lay observations. Luden testified not only that there was a strong scent of alcohol, but that there was a difference in the scent between whether the alcohol was spilled or consumed, that there was a difference in scent between whether the alcohol was recently consumed or consumed some time ago, that he could tell at least approximately the quantity of alcohol that was consumed based on the smell, and then ultimately his opinion that the smell was consistent with the number of beer cans that were found in the car. An ordinary person simply cannot offer those kinds of opinions, particularly that final conclusion that it was consistent with the number of beer cans. And then when you also look at, under Ramos, the emphasis on the training and experience, this becomes even more clear. Opposing counsel said that the reliance on training and experience made it a closer question. I actually think that makes it a less close question. That perhaps without that, we would be somewhere on the border. But when you look at all of the emphasis that the prosecution placed on this was clearly presented to the jury as expert testimony, and it was in fact expert testimony.
Mr. Cox, can you, I take it you disagree with Ms. Adams' characterization that the prosecution didn't really rely on the expertise issue in closing? Do you disagree that they did that, or is it sort of in the line of questioning and answers that were given?
I think the questioning and the answers is really the focus in this case. I don't have a copy of closing with me. I believe that there was a reference in closing to comparing Luden's testimony with CN's testimony.
Did they refer to him as an expert in closing?
They did not use the word expert. When they asked Officer Luden one of the questions, they I would argue intentionally danced around that by saying just based on your training and experience, but not being qualified as an expert. I don't entirely know what that phrase means, but they never did refer to him using the word expert. But I would like to compare the reliance on training and expertise in this case to that in Ramos. This court noted in Ramos that there were 6 questions that were asked that explicitly invoked training and experience. In this case, I counted 10 instances where the exact phrase training and experience was used either in the DA's question or in Officer Luden's response to that question. So really throughout this entire line of questioning, it was extremely explicit that this was about training and experience.
A person can be an absolute expert. We could have somebody who has conducted hundreds of hours of studies on intoxicated people and do all things, but ultimately at the end of the day, it's kind of what the opinion is, isn't it? I mean, ultimately at the end of the day, let's say hypothetically you introduce a guy that's done hundreds of hours of studies on intoxication, and then you say, did you look at this person? Did you have an opinion as to whether they were intoxicated? Which we all agree a layperson could testify to. Does that then, because this person has additional training and experience, does that make that opinion an expert opinion? Or does it just say, ladies and gentlemen of the jury, consider this for the weight that it's given?
Justice Boatwright, I think that it does matter. I don't think that asking a question and using the phrase training and experience creates a bright line rule that therefore it's an expert opinion. This court has rejected that sort of bright line rule, but I do think it's important. And the reason why it's important is that it lends the testimony an aura of expertise.
Were there, and I apologize for you, were there objections as to relevance, saying, I mean, it seems to me that these are kind of two separate issues. He keeps talking about his training and experience. Was there an objection saying, Judge, his training and experience is irrelevant?
There was one objection along those lines. His initial testimony about his wet lab training and things like that, the defense did not object to, and that was in accordance with Venn Alonzo, which said that simply explaining your training and experience is not objectionable. It's when your later testimony relies on it that it's objectionable. The one point where there was a relevance objection, that was when the prosecution asked if it was fair to say that without alcohol you might be out of a job. There was a defense objection to relevance at that point, because at that point the prosecution was really harping quite a bit on how central alcohol is to the officer's day-to-day duties.
But that really doesn't, that's not, pun intended, relevant to what we're deciding here, right?
I think that when you look at that line of testimony along with all of the other training and experience questions, it is relevant because it goes to how much the prosecution was painting this witness as an expert.
All right. Thank you, Mr. Cox.
I have a hard time crafting a rule or embracing the idea that we should craft a rule that says that where there's explicit reliance on training experience, it becomes problematic because, for example, in Venn Alonzo, I think Ms. Adams makes a good point. The forensic interviewer talks about credentials, and maybe, I can't remember in Venn Alonzo whether the forensic interviewer goes back and relies explicitly on her experience and training in offering lay opinion testimony about how children behave. But you know, it's already out there. It already has sort of the patina of quasi-expertise just based on extensive training and experience. So how do we draw that line? You say implicit, explicit? That's how we draw it?
I think it's less about implicit, explicit, and it's more that it's not a bright line rule. It's a factor. And I think that when you look at Ramos, Ramos really treats it as a factor. So in the question of whether this is something that a lay witness could or would be offering, one of the things that this court looks at is how much the witness explicitly relies on training and experience, or how much the prosecution explicitly relies on it.
So it's a factor, and given the constellation of all the circumstances here, it crosses the line.
Yes, and I think it crosses the line even if you don't consider that factor at all. I think when you read the record in this case, that factor, it really jumps out off the page. But if this court were to decide that that's not a factor whatsoever, I think the testimony here still crosses the line. I don't think an ordinary person can say someone who had their beer 5 minutes ago has breath that smells different from someone who had it half an hour ago, which really was quite relevant to the verdict.
It begs the question, I suppose it goes to your Shrek point ultimately, that can anybody really do that? And is there even foundation for lay opinion testimony on that topic?
That there wasn't any record developed below on that because there was no Shrek hearing. I'm aware of no cases that hold that there is any reliable scientific technique for determining those things. So I believe that that would fail a Shrek hearing.
Recency and quantity based just on odor.
Exactly. I don't believe there is any reliable scientific field on that. We certainly don't know if Luden was trained in such a reliable scientific field or if he applied it. So I believe that most likely this would have failed a Shrek hearing, but again, there was no record developed on that because there was no Shrek hearing. Which really is why it's so important that if someone's going to be offering this kind of testimony, they have to be qualified as an expert first so that we have a record on whether that really is a legitimate area for anyone to be offering an opinion on.
Mr. Cox, at the risk, oh, go ahead, Chief.
No. Well, I was just going to ask, with regard to the training and experience, you're relying heavily on the prosecution's reliance on his training and experience. Is that different from his explanation what his training is? If he hadn't have said things about he was trained in wet lab and metabolizing, but just said this is based on my training and experience, and the prosecutor relied many times on his training and experience, would that be the same with regard to whether we treat this as expert testimony?
Well, I think it really comes down to what he ultimately ended up testifying to. If he had given all of that wet lab testimony and everything, and then he had simply said, I detected a strong odor of alcohol, I don't think that we would be here today. I don't think that would really be an issue. It's when he went beyond that and said that he could tell from that odor recency, quantity, consistency with the number of beer cans, regardless of the reliance on training and experience. That's simply not something that an ordinary person would be able to opine on.
So can I see if I'm understanding you correctly? So what you're saying is even if someone is an expert, what they say may not be expert testimony depending on what they say.
Yes, I think that Ven Alonso actually explicitly said that you look at the line of testimony, you don't look at the person. And so here it was expert testimony when he went into all of that discussion of how alcohol metabolizes and how it affects odors and his ultimate opinion on consistency.
Thank you.
I was going to ask you, Mr. Cox, the arguments you made about Shrek hearing and whether this was reliable science, et cetera, may go to the harmlessness piece of this, but I really wanted to hear your argument on that. I have to say, for me, that's probably the most difficult issue in this case, why, assuming there was error here, it's not harmless.
So I'll address that, and just on the way to addressing that, I also want to address preservation because the prosecution argued that the final and perhaps most damaging piece of testimony, the consistency with the number of beer cans, that should only be reviewed for plain error. I disagree. At that point, the defense had objected at least 4 times to this entire line of questioning. To object a further time at that point would have been futile. The trial court was on notice that this entire line of questioning was objectionable in Mr. Kabugu's opinion. So moving on, assuming that we're reviewing this for harmlessness and not for plain error, I think it's important, first of all, to note that this court recently established that the burden is actually on the state to show harm. That was in James v. People, announced about a month ago. And in the state's harm argument, the state relies quite a bit on the notice issue rather than the substance of the testimony. And really, this court needs to be looking at both of those things. So there was harm from the fact that Mr. Kabugu did not have notice that this testimony was coming, could not hire an expert to refute it, could not cross-examine on sort of the legitimacy of this science, if there is such a science. But then the substance of the testimony was really what was quite damaging. Mr. Kabugu's defense was that he had very recently consumed a relatively minor amount of beer, so that he had gotten out of the car, he had taken a few sips, they had stopped to watch the unrelated traffic stop, and then to visit Mr. Kabugu's friend. And that at that point, he had decided to begin consuming alcohol once he was no longer driving. So testimony that his breath smelled like he had been drinking for quite some time rather than recency went directly to Mr. Kabugu's defense. And the other evidence in the case was relatively consistent with that. There was no evidence that he had been drinking earlier. Other indicia of intoxication, like difficulty talking or walking, were not present. Officer Luden explicitly testified that he did not observe those indicia of intoxication. So Mr. Kabugu's defense was, in fact, quite plausible without this damning testimony that... Go ahead, Your Honor.
Finish your thought. Go ahead.
Really, I was just going to say that the testimony was quite damning in light of the defense and in light of how the other evidence fit into that defense.
Well, speaking of what regular people would think, I mean, regular people certainly would look at the bad driving of the sort that we have here, coupled with a car that's littered with beer cans and these other indicia of intoxication about which there was undisputed evidence, and say, this person's drunk, and therefore this ultimately is harmless. What's your response to that?
My response is that the question when we're talking about harmless error is not whether the evidence would be sufficient without the error. It's whether the error influenced the verdict, or I believe it's whether there's a reasonable probability that the error influenced the verdict. And so, yes, those are certainly factors that the jury could have considered, but I believe that standing alone, those factors are not overwhelming. Some people are simply bad drivers. You know, there's really, I would not call the evidence overwhelming without that damning testimony.
Does it have to be overwhelming?
In order to find the error harmless here, considering the gravity of the error, I do believe the evidence would have to be overwhelming without it in order for this court to be assured that the error was harmless. Yes, as I mentioned, and the empty beer cans that were in the back of the car, there was also conflicting testimony about where those came from. Mr. Kabugu did testify in this case. He testified that he had left those beer cans there a previous day. So there was certainly conflicting evidence. There's no way for this court to know how the jury would have weighed that evidence or what conclusion the jury would have reached without this very damning testimony.
So one of the arguments that your opponent makes is this presumption that the prosecution's entitled to if someone refuses to take a blood or breath test, that that's a presumption of guilt. How does that play into this case?
First of all, I'd like to clarify, it's not a presumption of guilt. It's evidence that the jury is allowed to consider for guilt. And so the jury was allowed to consider that. The jury was also allowed to consider that Mr. Kabugu testified that he did take the breath test, and that simply the results of that, we don't know where the results of that went. It's not up to this court to judge the credibility of that testimony. For all we know, the jury may have believed that testimony. We simply don't know. So there was conflicting testimony about whether he agreed to that test. And in any event, that's simply a fact that the jury is allowed to consider. It cannot shift the burden. It would be unconstitutional, in fact, for that to shift the burden.
Is it a permissive inference instruction?
I don't recall whether an instruction was given in this case. I've seen quite a number of DUI and DWAI cases where an instruction is given. There is no Colgi instruction on this issue. And I apologize, I simply don't recall whether one was given here.
So was it just presented as the officer testifying he refused to take the breath test, and then the defendant testified, I did in fact take a breath test?
Yes, so the officer testified that he explained the express consent law, walked through the consequences of it, which include a revocation of your license as well as the refusal being admissible in court. And Officer Luden testified that he refused, and that he said he was refusing because he had done nothing wrong. Mr. Kabugu testified that he did not initially take the test at the time of arrest, but did take the test when he got back to the police station. And so we simply don't know which of those things the jury believed. So yes, going back to the merits of this, just to summarize, There were at least 10 questions or responses that focused on the officer's training and experience when discussing this. The officer testified that he had investigated 1 to 300 DUIs or DWAIs. He discussed his wet lab experience. He said that he might be out of a job if it wasn't for alcohol, because alcohol plays such a major role in his day-to-day duties. And so this was unquestionably presented to the jury as being expert testimony. And that especially comes out as Justice Gabriel noted in the cross-examination of CN. There were at least 5 questions targeted at her that expressly compared Officer Luden's expertise to hers. Let me ask you a little about what kind of training and experience. You don't really have formalized training in detecting alcohol. You've never done DUI stops, you've never done wet labs. Ultimately, the prosecution asked if a well-trained police officer, I'm paraphrasing a little bit, but would probably have a lot better understanding of what was going on as far as intoxication. And so I believe it really is ironic at this point to argue that this was lay testimony when at trial it was explicitly invoked as being a higher level of expertise, a higher level of knowledge than a lay witness could offer.
Do you agree her answer was no?
Her answer was no, but often the purpose of cross-examination is not to get the answer, it's really to make the argument. And so just because she said—
But it's not evidence.
It is not evidence, but it showed that the prosecution, successfully or not, was painting Officer Luden as having superior
And remind me, what
expertise.
did that witness testify to?
She testified that Mr. Kabugu had done some landscaping and yard work for her, and that he sometimes smelled like someone who, I believe the words she used were a stale odor of alcohol, and then she elaborated that that was like someone who had poor hygiene, so perhaps someone who had been drinking the night before and hadn't brushed their teeth. It's not entirely clear what she meant by that.
So it's pretty similar. She dated the time of the consumption of alcohol, right?
Not with anywhere near the same level of precision. Saying a stale odor is very different from saying I can tell the difference between 5 minutes and 30 minutes ago. She didn't give that sort of precision. So her testimony, and the Court of Appeals addressed this in its opinion when it contrasted the two, her testimony was simply a lay perception of a smell. There was no opinion that it was consistent with a certain quantity of alcohol, and there was no opinion about recency with that level of specificity. Stale versus fresh is very different from saying 5 minutes ago versus 30 minutes ago. If there are no other questions from the court, I would ask that this court affirm the Court of Appeals, because the Court of Appeals correctly held that this was expert testimony offered in the guise of lay testimony, and that it was not harmless. Thank you.
Thank you. Ms. Adams, you have some time.
Just as a factual matter, there was no discrepancy between the parties regarding whether or not the defendant refused to take a breath test in this case. The defendant had argued that he did take a breath test. The parties agreed that what he took was actually a PBT, or a preliminary breath test. But there was no disagreement regarding whether or not he refused to take the breath test under the express consent law. And back to this court's questions regarding Van Alonso and Ramos. In both of those cases, the court was very clear that just because the witnesses in those cases recognized the behavior based on their experience, or even in Ramos, what the court said was that despite the fact that this police officer had 9 years of experience as a detective and worked on thousands of cases involving blood, that alone did not elevate his testimony to expert testimony. So just because these witnesses have experience, that is not what determines whether or not it's expert testimony. In Ramos, the issue was that this court found that ordinary people would not be able to reliably differentiate between blood cast off and blood transfer. That was really the underlying basis for this court's decision. It was not the experience of the witness in that particular case. If the court has no further questions, we would ask that this court reverse.
Thank you. We appreciate the arguments of both counsel, very helpful. The court will now be in recess, and we'll give you time to ask some questions of these folks, and we'll come back out, not in session, but just out here on the bench, and you can ask some questions of us. Thank you. All right.
You may be seated. All right, well, there was the second argument. Again, the court threw our attorneys lots of questions, two very different presentations. The court's back there right now, starting to grind away on this, taking initial votes. And as I said before, once opinions come down, we'll get them to you. So with that, we're going to do exactly like we did last time. Come on down. This will be your only opportunity to ask questions about this very interesting case. Don't be shy. Here we go. And let's keep the side chatter to a minimum, please. Respect your fellow students asking questions here. Let's start over here.
Good morning. So as I understand it, you have stuck with this case from the beginning at trial court level. And so when you go into that level of trial, do you have this idea that you need to be prepared to go all the way to the Supreme Court, or does that kind of develop over the process?
Well, I guess just to be clear, I didn't handle this case at the trial court level, so I got this at the appellate court level, and I think Mr. Cox picked this up at the Supreme Court level. Okay. So he didn't even handle this in the Court of Appeals. So, but I don't think that we necessarily, maybe there are certain cases where we know this case might end up in the Supreme Court because it's an issue of first impression. In this particular case, after this opinion was issued, we received a few opinions from the Supreme Court talking about the difference between lay testimony and expert testimony. So, you know, without that, we might not have taken this case up to the Supreme Court. It's hard to say, but every case is different.
So yes, we do not handle this from the trial court level. Normally, our office, the same attorney handles it in the Court of Appeals and the Supreme Court. I took this over in the Supreme Court because the other lawyer moved on from our office. There are certain things that a trial lawyer does knowing that it might end up at a higher court in order to make sure the higher court looks at it. So objecting the right way to different things that come in really affects the way that the higher courts end up looking at it. So there is often an eye to what's a higher court going to look at. But a trial lawyer's first priority is to win the case at trial.
Thank you.
I actually have a question based on what the prosecution said. It's kind of for both of you, but you talked about training and experience, and I was wondering what you thought the difference between the two was and where you draw the line between having training versus your training being your experience.
So I don't think that there is a bright line between the two. I think people often talk about the two together as a compound noun because you get experience at the same time as you get training. Your experience does in fact train you. The real issue is whether the training and experience is something that an ordinary person off the street would know, or whether it's something that you have to have gone through some sort of specialized process to have.
Yeah, I think we actually agree on that.
So I was just wondering what your strategies were for organizing the points of the case so that you could best defend your client during the hearing.
Sure. So because I got this case at the Supreme Court level, it was already defined exactly what the issue was that we were here to argue. Normally what happens is I go through all of the transcripts and all of the filings and everything and kind of figure out what I think went wrong and figure out sort of what my line of attack is. Here, that step was already completed. So here it was really about looking at what other previous cases from the Supreme Court said and kind of putting together what facts from those cases I think would help me here. And then also, because I was going second in this argument, listening very attentively to her argument and knowing sort of what to pick up on and what to respond to.
Be forced to qualify police officers as experts in every situation. But really, what it comes down to is, I think some of the justices even touched on this during the argument, is that just because someone has expertise doesn't mean that the opinion that they're offering is expert testimony. So we really are just looking at the basis for that opinion. All the time, officers are explaining what their observations were at the scene, and those types of things are never expert testimony. They're simply describing what they saw or what they observed.
Thank you. I would agree in principle. We would draw the line differently in terms of where it becomes expert testimony, but certainly, you know, a police officer testifying, he was stumbling, I could smell his breath, that's not expert opinion. That's something that a police officer could testify to just like you or I.
So I have a question about the, sorry, blanked out. What qualifies, say, as drunk driving versus like bad driving, as you said in the thing over there. I'd just like to hear your opinion on that, and hers as well.
So I just want to clarify, the question was the difference between bad driving and drunk driving?
Yeah.
And really the difference is whether you're drunk when you do
okay,
it.
Sorry, but like...
to answer the question as simply as possible, yeah. You actually, to be guilty of drunk driving, you don't have to drive badly.
Yeah,
you
now
could just
that
be
I think
randomly
about that,
pulled
yeah.
over. But quite often, the fact that you're driving badly is what gives the police officer some suspicion.
Okay, well, is that like probable cause? Sorry, that went off on my question. But...
To pull someone over initially, you don't need probable cause. You need something lower called reasonable suspicion. To ultimately arrest them and charge them, you would need probable cause.
I think.
So I was wondering if you guys had done any activities in high school that helped you get to your career today?
I participated in debate in high school, which I think probably was helpful. But I was an English major in undergrad, so I pay attention in English class, work on your writing and your reasoning skills.
I would agree.
Thank you.
Research, political science, if you have those kinds of classes.
All good stuff.
Yes, sir.
Would the experience Officer Luton had, including the couple hundred of DUI cases he was involved in, not contribute to the definition of an expert testimony as laid out in Venalonzo?
That was like our whole argument. I really think, and obviously we're going to answer this differently, but I think it really comes down to the basis for the opinion and whether this is something an ordinary person could understand.
Yeah, we agree on the rule, but my answer is yes and her answer is no.
So it was mentioned in the beginning that there was a second officer at the scene. So if this case hypothetically was to go back to trial with the cop in question's testimony thrown out, if the other cop presented the same information, would that information count, or would it be counterintuitive?
You're talking about what if this court were to find this was expert testimony that was inadmissible, then it wouldn't be. Then the other officer couldn't provide that either without being qualified as an expert.
So my question is kind of odd. I was just wondering why metabolized would be a word that would be coexistent with expertise, and I was just wondering if
the argument was like based off of the eloquence of language would mean expertise or not.
Well, and again, my argument is that that's not a specialized term that ordinary people don't understand. I think that's probably in your high school biology class you learned about metabolism. But really, what the court cares about and what they've talked about in other cases is really what's the substance of the testimony. It doesn't matter so much what the jargon is that's used by the witnesses, but what really are they trying to say? What's the substance of that testimony?
So I think sometimes the jargon does matter. I think that metabolize might be sort of on the fence. You probably do learn that word in your high school biology class, but spoiler alert, most adults have forgotten high school biology. So, you know, I think that that is something, especially when you look at the testimony as a whole with the rest of it, using that technical language does sort of push it a little further in the expert direction.
I was wondering about like the differences between prep for like trial court, appeals court, and Supreme Court, because obviously in trial court you're like prepping witnesses for testimony and that kind of thing. In Supreme Court you're making decisions that will affect other court cases. So I'm really just wondering like how you go about preparing for those kind of things. Thank you.
So in Colorado, both on the prosecution side and the defense side, we separate out into specializations. So we only do appeals. We don't do trials. But the kind of preparation is radically different because in a trial, you're trying to convince a jury. You're trying to prepare witnesses, get the right information out of witnesses. What you're really trying to do at trial is establish facts. Whereas in both the Court of Appeals and the Supreme Court, you're trying to establish law. So you're trying to say, how does the law apply to those facts that came out at trial? So our work is a lot more academic in some ways, whereas a trial lawyer's work requires sort of more charisma, more intuition.
Yeah, and I think we're just more concerned too, in some ways, with the global application of the law that we create in these cases. How is this rule that they decide in this case going to apply to future cases? And I think in the trial court, you're more focused on your particular client and getting your client acquitted or getting a conviction, as opposed to looking at how that's going to impact future case law.
Thank you.
Hi, I was just wondering, I was curious where you guys pursued your college education in law, for both of you.
So I grew up in Colorado, so I went to the University of Northern Colorado for undergrad. Majored in English and speech communication, and then I went to CU Law School in Boulder.
So I actually grew up in Canada. I did my undergrad at the University of Toronto in political science and social justice studies. I then took about a decade off and worked in the private sector. Then I moved to the United States, did law school at Northwestern University in Chicago, and then moved here for this job.
I actually have two questions, sorry, but my first question is, one of the big questions I feel like in the case was, how do we know it was from the smell was from his breath and not like something spilled on his shirt? Sorry if you went over this and I just missed it, but when after he was arrested and brought back to the precinct, why was it not tested like on his jacket if he didn't have alcohol on him?
That's a good question, and those are the kinds of things that we often don't know once it's on appeal, because all that we get is the transcripts of what happened at trial or at any hearings. We don't necessarily get all the officers' notes and things like that might shed more light on it. What we do know is that when the police were chasing after Mr. Kabugu and he went to the ground, the police actually kicked the beer can out of his hand. So it's quite likely that beer spilled, but no one really knows.
Yeah, I mean, we obviously weren't involved at the trial court level. I imagine that if alcohol had been spilled on the jacket, the defense attorney at trial would have admitted that into evidence, but we really don't have any information about that.
Okay, thank you. And my second question is, if you get a case with about something that you aren't completely familiar with, for example, the whole wet lab thing and the metabolized alcohol, how would you go about it if you weren't familiar? Would you go in depth to learn it yourself, or would you recommend a different attorney that has more experience in it, or just completely depend on expert? How would you go about that whole process?
Well, I work at the Attorney General's office, and our appellate division has over 30 attorneys. So we all have varying degrees of expertise in certain areas. So we often will confer with each other. It's a very collaborative environment. When I got this case, I actually did go talk to one of my colleagues who had been a district attorney and asked her about these wet labs, because this isn't something that we have a lot of experience with in the appellate world. So I did turn to her just to get her take on it and ask how these things worked, just to get some background. But we do a lot of research, and we do rely on our colleagues too.
Pretty similar answer. I have a lot of more experienced colleagues. I have Google, and I have friends who work in trial offices who know a bit more about these things than me.
Okay, thank you.
Thank you. Do you get the same amount of time to allocate for each case, or is it variant on each case?
It varies with each case. Some cases, the legal issues that we see in them are things that we've litigated 1,000 times before, and every case is different in some way, but it's a little more efficient when it's an issue you already know about. When it's your first time facing something, or when it's the first time the court is going to be facing something, you're going to put more work into it to make sure that you're covering all your bases.
All right, thank you.
Why is it so important that it has to be like expert or just normal people opinion?
It matters because there's a lot more procedural safeguards that come in if it's expert. So if it's expert, then we would have had to get notice before trial, and then we would have to already get the reports. We'd be able to hire our own expert to dispute those reports. There's also a hearing that we would go through where we figure out if it's a legitimate expertise or whether it's sort of fake science. And if it ends up being fake science, it can't come in at all. So it matters quite a bit in terms of what ends up being able to come in and how prepared we are for it.
Okay, thank you.
Can you remind us again about the various options that the court will have once they do issue their ruling, and what that would mean for Mr. Kabugu? The students don't know what's going to happen to him, and they want to know what the options, and they want to be able to understand the ruling when it does come down.
Well, I mean, the court has multiple options. They could affirm the Court of Appeals, in which case the case would go back for a new trial, at which point they wouldn't be allowed to admit this expert testimony at trial. So whatever this court decided was expert testimony, that would be inadmissible, and they would do a new trial.
And they could not just submit it as lay testimony at that point?
Well, if the substance of the testimony isn't lay and they decide it's expert, I mean, it's of course our position that it's all lay, but if they were to determine that it was expert, then it wouldn't be able to come in unless they were to qualify the witness as an expert. They could affirm, they could reverse the Court of Appeals, and they could say this was all lay testimony. It was perfectly proper to bring this in. We're going to affirm these convictions. They could decide, they talked a little bit during the arguments about harmless error. They could say, we're not going to determine whether or not there was error here, because even if there was, it was harmless. So we're going to reverse the Court of Appeals in that instance too. They may find that some of the testimony was lay and some was expert, and then they may have to decide whether or not that was harmless.
And has Mr. Kabugu been out of jail this whole time while this process is happening? He has not served any time so far?
In this particular case, he is not currently incarcerated, but quite often our clients do remain incarcerated throughout the process.
So I suppose I have a secondary question. So I was just wondering if a lot of experience, say, on this particular issue, say they were bar hopping a lot or something like that, and they knew it based on that, would that be considered expert because it's based on a lot of experience where they might know such things as, say somebody had it 5 minutes ago, they would be able to kind of iffily figure out when or how much they had based off of that? Would that be considered expert or just experience levels?
Well, again, our position that it really comes down to specialized knowledge. If it's something that you could learn based through just the ordinary course of your life, if something an ordinary person could understand and experience, then we would argue that it's lay testimony.
That would be a tougher case than this one. It would really, it's hard for me to answer that because the test is whether an ordinary person could be expected to know. And I guess maybe this person you're talking about is not an ordinary person. So it would be a closer call, but it's hard to say yes or no.
Is it common in case briefs for some ideas to be dropped when it comes to presenting to the Supreme Court? Like, I know one of the things that was in the case brief was like opening the door. Can you talk about like why that wasn't talked about today, or?
I think I really just ran out of time. I mean, we have only a limited amount of time, so we want to put forth our strongest argument, which for me was the fact that this was just lay testimony. I had a few minutes at the end where they wanted to talk about harmless error, so we jumped to that. But the arguments that are in the brief are still being considered by the court. Whether or not they choose to rely on those in making their decision is up to them, but those arguments are still for them to consider.
If you two were to swap places, would you guys have the same views?
I mean, I think that we're each doing our job. I'm the prosecutor. If I were a defense attorney, then I'd be making similar arguments to, what defense counsel is making here, because my job would be to defend my client. So we each have to make the best arguments for our position. Prosecutors have a different job in that we're trying to make sure that justice is done. So it's not simply trying to win a case. We really want to make sure that we reach a just result in the end. But I mean, I think I can certainly see what my position would be if I were on the other side and advocating for the defendant in this case.
So I think there's a reason we haven't switched places, and that's because I believe our society puts too many people in prison. And so it's hard for me to imagine me making arguments that would put more people in prison. That's really what it comes down to for me.
Thank you.
Thank you. Let's have a big round of applause for Ms. Adams and Mr. Cox. Thank you both very much. The court is ready to come out. Thank you very much. So with that, the Supreme Court is ready to come out and entertain your questions. Again, I know I sound like a broken record, but please don't ask anything about the cases. The court will not be able to answer them. So with that, Justice Carlos Samore, Justice Rich Gabriel, Justice Brian Boatwright, Chief Justice Ben Coates, Justice Monica Marquez, Justice Will Hood, and Justice Melissa Hart. All very diverse backgrounds, lots of different experience. We've got some trial court judges on the bench. We've got some prosecutors, defense angles, all kinds of things. So please, don't be shy. Come on down. Ask the questions, and the chief will take it from here.
Hi, I'm interested in the...
Please keep the side chatter down.
In the bipartisanship of justices and the nomination process that goes with that. So I was just wondering if you could take me through the process of being elected as a justice and how you keep politics out of it.
Okay, maybe being chief, I'll start with the first one and then let my colleagues jump in. Basically, we have a system, it's not unique, but it's different from most states or many states in that our system for being picked is we don't have elections like many states, and you've probably heard some of the controversy about that. We got rid of that system about in the late 60s. And so for us, there is a constitutional formula for picking commissions. And they, in effect, take applications when there is an opening. And this is for judges all over the state, not just the Supreme Court, but for the Supreme Court too. And then they get to pick 3 people, 3 names that they will send to the governor, and the governor's choice is only among those 3. That's all he can choose from, which is sort of a flip side of the United States Supreme Court, where the president can make a nomination and then it's confirmed by the Senate. Opposite way. Because of the way these commissions are picked, they're picked in a constitutional formula that's got a certain number of non-lawyers, a certain number of lawyers. The governor picks the non-lawyers totally by himself, but the lawyers have to be a vote of the Attorney General, the Supreme Court Chief Justice, and the governor. So it's this complicated formula. And by the way, there's a certain number that are from each district for the Supreme Court, each congressional district. So the system is designed in such a way as there is no one person that can pick, no one party that could influence the picking in that way. And the design is so that it will be based more on your experience, and we like to refer to it as a merit system because we all think we're meritorious. But it is a system that's designed to push politics to the extent it can be involved as far back into the background as possible.
And I think the one follow-up I'd have to that is I think Justice Samore and I both were appointed by Republicans to a Republican governor to the trial court, and then by Governor Hickenlooper, who's a Democrat, to the Supreme Court. So it really confuses people when they want to know what party you're in. So.
And one thing that I would add, on these nominating commissions the chief referred to, no political party can have a majority of more than one. And on the application we fill out, there is no spot for indicating what political party you're a member of. It's never asked, ever. And the governor didn't ask, so.
Thank you very much.
So I suppose my question kind of has two parts to it, and I was wondering just what type of credentials you had to have to be a Supreme Court member, as well as if there was an age limit.
I'll just go down the line. Well, taking the last part first, there is an age limit. You can't serve after the age of 72. So there's that. In terms of the credentials that you need in the first place, you have to have a law degree, you have to be on the Supreme Court, right? And you have to have been a lawyer for at least 5 years. As a practical matter, I think that, typically it's somebody who has probably at least 15 years of experience as a lawyer, usually in different areas of the law, so that there's some diversity of experience to suggest that you would be well suited to the task of addressing many different areas of the law. So those are some of the baseline credentials. Although we do, as Mr. McCallum noted, we have very different backgrounds. Some of us come from more of a trial background. Justice Samore, Justice Boatwright, and I were all trial judges. Others, like the chief, for example, he was an appellate specialist. Justice Hart was a professor, so there's no one sort of resume that gets you in the door.
Okay. Thank you.
Okay, so you guys get your debriefings before you view cases. Do you guys usually form an opinion before you come to the case and then expect to be proved wrong or right, or do you try and just get an overview and attempt to stay not on either side?
Thank you.
I'll jump in. So we all prepare independently, and we all prepare, I think, differently. What I do is I'll read the briefs. I kind of take notes on the briefs. I'll read the parts of the record the parties have cited. I'll read the case law they've cited. And I will come to a preliminary leaning. In fact, on my notes I write, it literally says preliminary, a view of which way I'm leaning. And I will also make note of the questions that I have literally on my notes, and I'll prepare to ask them. So I'll have a preliminary view. I get asked a lot whether I change my mind. And I will tell you, on this court, I bet 25% into the time. I kind of come out somewhere, sometimes change the whole result, but sometimes just change my reasoning based on what I hear at oral argument. Before I was here, I served on the Court of Appeals, which is the lower level appellate court in this state. There, I would tell you, in honesty, I didn't change my mind that frequently because we saw cases on the Court of Appeals that were easier. Parties have a right to appeal to the Court of Appeals. You don't have a right to come to the Supreme Court, which surprises people. We choose. But on the Court of Appeals, people, if you got, say a criminal defendant and you've been convicted, I take my shot at an appeal if that happened to me, and sometimes the arguments aren't as strong. So my mind got changed less there. But I have a preliminary view coming in, but it gets changed based on the argument with some frequency.
Thank you.
Okay, thank you.
All right. Is it ever a problem for you guys that you are simultaneously deciding a result on a specific case and establishing precedent, or do those things just coincide enough? So.
Good question.
That is a good question.
Anybody?
I think that's actually one of the joys and the challenges of this role, because the cases that we do decide, we are mindful that they will be binding on all lower courts in Colorado. And so one of the things that I know keeps me up at night, and I think keeps my colleagues up at night, is not only are we trying to decide the case under the facts right in front of us, but we also have to be really thoughtful about how we write that decision because it's going to be applied in future cases. So we're constantly trying to think of other scenarios in which the rule that we write might be applied and try to avoid mischief, unintended consequences, misunderstanding of what we were trying to accomplish. But yeah, it's the fun part and the hard part.
And is either role more important to you guys, or do you treat them both?
I would say it's part and parcel of making the decision in the case before us.
Part of, I'm glad you said, we all have heard versions of older judges say something to the effect of, if you don't write it, it can't be wrong. So you got to be really careful to not say more than you need to and get the rule just as Marcus said.
Thank you.
Thank you.
So earlier someone said that you take about 8% of all the cases that appeal to you. My question is, what factors do you use to determine what cases you take and what cases you don't take?
Okay, thank you. Anybody want to comment on search?
So there are all kinds of factors that we take into account to decide whether to take a case or not, and it actually takes up a lot of the time and a lot of our work that we spend on cases that come our way. And sometimes people don't realize how much time that takes. But, we look at whether the Court of Appeals, which is the intermediate appellate court, so that's the court between the trial court and us. So we look at first whether we think they got it right or whether there was an error. We look at whether that decision was published, because most of their decisions, most of their opinions are not published. And we worry about published because those are the ones that have precedential value that people out there can rely on. We look at things like, is there a conflict? Is it an area of the law where one part of the Court of Appeals has felt one particular way about it, but a different panel from the Court of Appeals feels differently about it? And the Court of Appeals sits in panels of three judges, and they're not bound by each other's decisions. And so one panel can reach one particular decision on an issue, and a different panel can come to a different decision on that same issue. Well, that creates problems for the trial courts when they're looking for guidance. If they have a decision from one panel of the Court of Appeals that says X and a different one from a different panel that says Y, which way are they supposed to go? Which one are they supposed to rely on? And so we look at whether it's something we need to clarify, an area of the law that needs clarification. We look at whether it's an important issue for the state of Colorado, for the people of Colorado. We look at whether it has policy ramifications, again, for the people of Colorado. So there are a whole host of factors that we look at in determining whether to agree to review a case. We're not a court that has been charged with simply looking at whether there was an error or not. And so we have to look at all kinds of factors before we decide whether to accept a case or not. Does that make sense? Yeah.
Great, thank you.
Thanks.
Thank you.
So you mentioned that when you get your briefings, you write down questions, but when you're actually in the trial, how do you determine who asks their questions? Do you have a specific order or anything, or is it just kind of free for all?
There's a lot of kicking that goes on.
It's hard on in our courtroom. The bench is a little bit rounded, so I can see. Right now, I can't see Justice Hart very well. We just pay attention to each other, and I'll lean in. And I always admire how polite my colleagues are. Are you done, Chief? Before you ask the next question. I think that's rare, and it's something that I'm proud of, that we pay attention to each other. But I literally will look down the row, see if anyone's leaning in, and we try not to monopolize the time. Sometimes any one of us could be more passionate about one case than the other.
There is sort of an unwritten rule that you're supposed to defer to your more senior colleague if you start talking at the same time. And so, sometimes you'll see that happen too, where we'll realize, Justice Marquez, who's senior to me, is getting ready to ask a question.
You start to get really in tune. You can hear someone taking a breath.
Yeah.
You hear them go, and then you go. like that, so you kind of know when someone's going to ask a question.
See somebody lean forward to the mic, like
Yeah.
waiting for an opportunity to jump in. But you're right, it's a good observation. There is, unwritten, but there is a kind of an oral argument etiquette that's observed in the way we do this.
Awesome. Thank you.
Thanks.
What factors of someone's argument is usually most convincing for you?
Whether they're correct.
Really, that was enough.
That's really an excellent question.
It is a good question.
It is,
So, no, I think that's a really excellent question, and obviously we think they're correct on the law. I think all of us will start with the law and where the law goes, but we take cases because the law may not be clear. We certainly have to think, does this make sense in light of our other precedent? As Justice Marcus said, we think about unintended consequences of what we're doing. Is there, to me, are you making if you come and make conclusory statements in your oral argument, that's less persuasive than you say, here's why I win, I got 6 reasons, and they all make sense and they fit together well. Those kind of things are persuasive to me. There's a bit of an instinct, too. Justice Boatwright talks about a muscle to making decisions and exercising a muscle. I find that to be true. Does it make sense? I mean, we want to reach conclusions that are intuitively make sense, but there are times when the law takes you in a way that may be counterintuitive. But for me, those are all those things that persuade. Go ahead, I'm sorry.
Well, I was just going to add one other thing, and that is that at this level, when you see somebody coming in and making an appeal to emotion, it almost seems to backfire because we tend to be much more logical. It's not like doing jury work where sometimes appealing to emotions can really help you. I think here it hurts you, typically.
And the only thing I would add is I think that the advocates who are most helpful to us are the ones who put themselves in our shoes and think about, not only do we have to decide this case, but we're going to have to write a rule that's going to apply to lots of other cases. And so you heard some of the advocates today talking about the rule that they would propose that we adopt. That's helpful to us when we're trying to decide these cases.
That was one of the reasons I asked one of the lawyers that question, and it's we are trying to figure out, okay, what rule are they asking us to apply? And then, we want to know, is this something a rule that we think is going to be an appropriate rule to adopt? Is it going to be practical? Is it going to be, all those things? And the other thing to keep in mind is, people forget that judges, and this applies across the board, not just at the appellate level, but people forget that judges are human beings. We're people. And so, we bring different backgrounds and experiences to the bench, and so different things are going to be persuasive to each of us. So there are all kinds of things that I think we take into account in figuring out what's helpful and what's not.
Gene, you thought you weren't going to get much of an answer. Look at that. Yeah.
Give it the signal that we've got time for 2 more questions to take here, and then wrap us up, please. Thank you.
Okay, hi judges, good afternoon. I can say safely that I'm sure that all the students here are very thankful that you guys are here today with us. But I was just wondering if you guys really enjoy coming out into the community and doing these things, and if, what your favorite part about it is.
Yes, I think I think we all enjoy it. I really enjoy it very much. When, as Justice Hood mentioned, before I joined the court, I was a law professor at CU Law School in Boulder, and one of the things that I did when I was there is start a program where law professors and law students and lawyers come into high schools and do a lesson for Constitution Day, which is September 17th. Every year we celebrate the Constitution, and this reminds me of why I love being around high school students. You guys are so open to ideas about the law and excited about the law and not jaded yet. Maybe never.
Give it time.
So it's a lot of fun to think about our role and the role of the lawyers from your perspective and to have that interaction. I think it keeps us fresh.
And this is one of my responsibilities is to come out and with help pick the school and come out and prep the teachers, and I just call it food for the soul because I've been on the bench between the trial court and here for 19 years, and I've never had anybody file a lawsuit to tell me to introduce me to a great young person. So the opportunity to meet all of you guys and spend time with you is really exciting. And I think for all of us, it's one of our favorite days of the year. We do it twice a year, and we love it. So.
Awesome. Thank you.
I was just wondering, when you began in law, did you envision yourself going to the Supreme Court level, or is it just something that developed as your career did?
That's a good question.
Anybody want to answer in particular?
You just
Well,
run down the line.
Yeah,
I just got down the line.
Yeah.
So when I started law school, I did want to be a judge. I don't know that I could ever have imagined that I'd be a part of the Supreme Court. It's a huge honor. It's unbelievably humbling. And I just got on the court. I'm the most junior justice, so I'm learning the ropes still. I think I'm my third, fourth month on the bench.
Yes, so I did not ever dream of being here. My career was as a business litigator, an intellectual property litigator. I was the first generation in my family to go to college. And I got a lot of blessings and a lot of help to get through college and law school because we couldn't have afforded to go. And I always felt an obligation to give back. So somewhere along the line, as a trial lawyer, it occurred to me the highest calling to give back of a trial lawyer would be to be a judge someday. So it was probably 10 or 15 or 18 years into my career where I first thought about maybe being a judge. And then after being on the Court of Appeals for a while, I thought, because my background is somewhat different than my colleagues, perhaps I had something that I could contribute. So I tried.
Yeah, I did not. I knew I was going to be a lawyer since I was 5. My dad was a lawyer, and I inherited that. And I thought that's what I was going to do. And then I had a judge treat me very, very badly in court one day. And I thought, there's a better way to do this. And so that was the day I decided I wanted to be a judge. And then I was a trial judge for 12 years and thought I would do that forever. And then when I applied, there were only 2 of the 29 appellate judges at that time had trial court experience. And much like Justice Gabriel, I kind of thought maybe I could bring something to the court. So it evolved.
Yeah, and I never really thought about it before either. Maybe this sounds selfish, but I got into this appellate practice largely because I really enjoyed it. It really pumped me up. Felt like I was doing something important. And it was really interesting and fun. I was one of these appellate lawyers like these folks that have argued in front of. And over the years, it just became a natural progression to think about then switching sides of the bench and deciding in the appellate forum rather than advocating.
I originally I was a teacher before I came to law school, and so I originally thought I would do education law, and my career path took some really interesting turns. I wound up at the Attorney General's office. But I did not imagine being here. Like Chief Justice Coates, I did what the Attorney Generals that you saw today do. And in fact, my very first argument before this court was one of these courts in the community experiences. And I have to say, as an advocate, it's terrifying to have 500 people behind you listening to everything you say. So I think over time, I realized I had a tremendous love for the appellate work specifically, and just kind of ended up drifting in this direction. But it wasn't a plan.
Yeah, I didn't have a plan. I didn't plan to be a lawyer originally, and after deciding to go to law school, I was more intrigued by the idea of doing trial work, and so I did a bunch of that on both sides of the aisle, primarily in criminal. And over time, I just came to really value the role of the judge, and I like the idea of being the neutral and trying to make sure everybody got a fair shake. So that took me to the trial bench, and then as I got older, I started thinking about how it's nice to have a little bit more time to think carefully about things and to write things. I've always enjoyed writing, and so that's what led me to the Supreme Court.
Yeah, I'm rounding it out. It didn't occur to me when I went to law school or graduated from law school that I would be a judge of any sort, actually. I clerked on the U.S. Supreme Court for Justice John Paul Stevens, and I knew that being a justice on the highest court that made decisions was a really interesting thing, but it wasn't something I imagined that I would do. But as a law professor, I love reading and writing, and I got very involved in worrying about and working on the access to justice gap in our court system in Colorado and really all over the country. And so actually I started thinking about joining the court more from that perspective, that the court as sort of the stewards of our justice system in the state has a really important role in trying to solve those problems. And that was what brought me to start thinking about it some years ago.
Thank you all so much.
Let's have a round of applause for your Colorado Supreme Court. All right, SaberCats, you have been absolutely fantastic. I'd like to also, my colleague John Sarche and I have been taking the court around for about 12 or 13 years now. I want to give a shout out to the sound people. Ladies and gentlemen, you did a fantastic job today. This is the cleanest sound we've ever had. Loved it. I'd also like to give a thank you to the Fort Collins Police Department for providing us a safe environment to hold our hearings today. And with that, I've also got some instructions here as to how we're dismissing.
Thank you. Ladies and gentlemen of the court, from Fossil Ridge High School's heart and mind, thank you very much, not only for what you do every day, but for being here in our school and educating us on how this works. Ladies and gentlemen, everybody, what we're going to do is we're going to dismiss the justices first so that they can get to the media center and get their lunches. You'll find name tents on tables in there for you. Teachers that have students going to the luncheon, please hang tight just a few minutes, then we'll get you going, and then everybody else will dismiss you after that. Thank you again. You guys are not coming to the luncheon, is that correct?